Okay, if there are no conflicts, you guys are good to go.
Good afternoon. My name is Phil Dubois. I'll be your presiding judge this afternoon. Well, let's just get right to it. Prosecution, are you ready for trial?
Yes, Your Honor, after a few preliminary matters.
All right, we'll get back to that momentarily. Defense ready?
Yes, Your Honor.
All right. Prosecution, preliminary matters?
At this time, would Your Honor like the prosecution to make appearances for the record?
Yes, please.
Good afternoon. My name is Hannah Feeney. I will be delivering the opening statement, conducting the direct examination of Alex Cifuentes and the cross-examination of Avery Becker.
Good afternoon. My name is Anna Carrington. I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Professor Blake Van Owen.
Good afternoon. My name is Anna Kabuchin. I'll be conducting the direct examination of Kyle Kuzak, the cross-examination of Taylor Perkins, as well as presenting the closing argument. May our witnesses please introduce themselves?
Yes, please.
Good afternoon. My name is Grace Oliver, and I am Alex Cifuentes.
Good afternoon. My name is Kate Malloy, and I am Detective Jordan Markowitz.
Good afternoon. My name is Pilar Melendez, and I am Kyle Kuzak.
Prosecution, any more preliminary matters?
Yes, Your Honor. Let the record reflect that the prosecution roster, as well as the pronouns for all prosecution witnesses, have been posted in the chat, as well as that the roster is available for download by all jury members.
Very good, thank you. Any other preliminary matters?
Yes, Your Honor. Before we begin trial, we would like to verify a few of the procedures of this online trial. Specifically, the prosecution will be admitting evidence pursuant to Rule 7.4 of the Rules of Competition. As such, any exhibits displayed on the screen will be assumed to not be seen by the jury unless we specifically ask to publish. And we will only ask to publish when we intend to show it to the jury following admission.
Very good.
May we have, and as exhibits are assumed to not be seen by the jury until published, would the court like us to ask permission to display exhibits each time, or simply to let the record reflect such?
I'll just let the record reflect, it's fine.
Yes, Your Honor. Furthermore, may we have permission to modify or zoom into exhibits for purposes of clarity?
I'm not sure what you mean by that. Tell me again.
Yes, Your Honor. Some of the writing in the exhibits is extremely small, and we are asking permission to be able to zoom into or otherwise modify the exhibits to make it clearer for the jury so that they can understand what we are referencing.
That's fine. Anything else?
Yes, Your Honor. Additionally, while each of the attorneys and witnesses have made attempts to be in a space with the best internet capabilities possible, if at any point you are unable to see or hear us, please feel free to interrupt us.
I am not shy about things like that, so I will do so.
Also, Your Honor, for the record, all witnesses will be present for the testimony today and may not be sequestered pursuant to Rule 5.3.1 of the Rules of Competition.
That's fine.
Does Your Honor intend to constructively read the jury instructions before or after closing arguments?
Well, it would certainly typically be before. My understanding of this competition is we don't read jury instructions at all. Tell me if I'm wrong.
Yes, Your Honor. I am asking if you intend to constructively read them before or after.
Oh. We can definitely constructively read them, yes. Always my preference. Anything else?
Yes, Your Honor. At this time, we reserve all remaining time from closing argument for rebuttal.
Fine.
And finally, we are confirming for the court and jury that the complaints, stipulations, and All preliminary matters have already been incorporated into the record.
Yes, that's fine as well.
With that, we are ready to proceed to opening statements.
All right. Does the defense have any preliminary matters?
Yes, Your Honor. The defense would like to introduce themselves at this time, and then we have a few further preliminary matters to attend to.
All right, go ahead.
Your Honor, opposing counsel, and members of the jury. My name is Jaden Inks, and I will be delivering the opening statement, giving the direct examination of Professor Blake Van Owen, and giving the cross-examination of Alex Cifuentes.
Your Honor, opposing counsel, members of the jury, my name is Brendan Maher. I will be delivering the direct examination of Taylor Perkins and the cross-examination of Kyle Kuzak.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Will Damon, and I will be delivering the direct examination of Avery Becker, the cross-examination of Detective Jordan Markowitz, as well as our closing argument. At this time, our witnesses would like to introduce themselves.
Your Honor, opposing counsel, and members of the jury, my name is Christian Murray, and I am Blake Van Owen.
Your Honor, opposing counsel, and members of the jury, my name is Jet Fisher, and I am Taylor Perkins.
Your Honor, opposing counsel, and members of the jury, my name is V. Wing, and I am Avery Becker.
All right. You mentioned preliminary matters.
Yes, Your Honor. Let the record reflect that the defense has also posted our rosters within the chat, as well as pronouns of each of our witnesses and our witness order. Our trial roster is also available for download by any jury members.
Very good.
As well as we ask that our timekeepers on both sides be allowed to post in the Zoom chat to keep us on time in our trial, making sure that each attorney and each witness, and for the sake of the jury and your honor, know our time's restraints within the round.
That would be fine.
There are no other preliminary matters, Your Honor.
All right. In that case, let's proceed to opening statements of the prosecution.
Yes, Your Honor. Before I begin, can Your Honor see and hear me all right?
Yes, ma'am.
May it please the court?
Yes, go ahead.
A mask can't hide the truth, and the truth is in the map, messages, and motive. It was Friday, March 6th, 2020. Mackenzie Brackman, a local defense attorney, was alone in his home on South Flower Street when a masked intruder tried to enter his front door, but it was locked. The Ring doorbell security system was set off. The intruder went around to the back of the residence, and in a panic, the victim grabbed a kitchen knife to defend himself. When the defendant entered through the back door, a struggle quickly ensued over that knife. The defendant wrestled the knife away from the victim before stabbing him in the back. That's when the defendant ran. The victim tried to follow to the front door before pulling the knife out of his back and rapidly bleeding to death. Mackenzie Brackman died in that home invasion. But that intruder's mask, Avery Becker's mask, can't hide the truth. And the truth is in the map, messages, and motive. After a thorough investigation, we charged Avery Becker with 2 crimes: murder in the first degree and second-degree burglary of a dwelling. But to understand murder in the first degree, first we have to talk about second-degree burglary of a dwelling. It says that on or about March 6, 2020, Avery Becker broke an entrance into or unlawfully entered a dwelling with the intent to commit criminal mischief, which simply means to damage another person's property. Now, let's talk about first-degree murder. The judge will tell you that Avery Becker is guilty of first-degree murder if Mackenzie Brackman was killed by anyone, while Avery Becker was committing second-degree burglary or in immediate flight from the scene. We will meet our burden and prove Avery Becker guilty of both charges because a mask can't hide the truth. And the truth is in the map, messages, and motive. Let's break that down. A map. You will hear from Detective Jordan Markowitz, the lead investigator in today's case. She will tell you about call detail records that put the defendant's phone at the victim's house at the time of his murder. You will hear how the phone movements show the defendant staying there long enough to commit the crime. Speaking of phones, pay close attention to the messages the defendant sent to Alex Cifuentes, a teammate of Miss Becker. Miss Cifuentes will tell you how this kind of mischief wasn't out of the ordinary for the defendant. After all, she had vandalized the victim's car only days before. You will hear how in these text messages, the defendant confessed to planning to commit this crime just before Mr. Brackman's home was broken into and he was murdered. Now, we've talked about the map, we've talked about the messages. Let's talk about the motive. You might be asking yourself, why would a high school student commit such a crime? You will hear how the victim was the defendant's mock trial coach, and all the bad blood between them, and how upset the defendant got when she was kicked off the mock trial team. You will hear from Kyle Kuzak, a crime scene reconstructionist who worked with Detective Markowitz on this case. And she will tell you how the crime scene is consistent with the defendant's motive and how this was a burglary gone wrong, just like what Miss Becker threatened to do in her texts to Miss Cifuentes. But for everything you'll hear today, you won't hear that the defendant intentionally killed the victim, because that's not what happened. And it's not what we charged the defendant with committing. Instead, this was a burglary gone wrong, and Mackenzie Brackman died as a result. That is first-degree murder. A mask can't hide the truth. And the truth is in the map, messages, and motive. After you hear all the evidence, it will be clear that Avery Becker committed this crime. And that is when my co-counsel will ask you to deliver justice for the victim and find Avery Becker guilty of both charges. Thank you.
Thank you, counsel. Defense opening, please.
Your Honor, opposing counsel, and members of the jury. My name is Jada Ninks, and my co-counsel and I are here today on behalf of our client, the defendant, Avery Becker. This case is as easy as 1, 2, 3. 1, tragedy. As you heard in the prosecution's opening statement, the well-loved coach and respected attorney Mackenzie Brackman was found dead in his home on March 6th of 2020. We agree with the prosecution on these facts. However, it is where we disagree, which is why we are representing Avery Becker today. 2, tainted. In the investigation done by the police on the prosecution's side, our client, Avery Becker, was accused of murder. Miss Becker was charged with first-degree murder and second-degree burglary of a dwelling. These charges are an example of the tainted police work done by the prosecution that was not founded on truth. Time and again, the prosecution's police work proved to be flawed, and there were so many holes within their case that they cannot fill. There were missing photos, questionable evidence, and detectives whose work was rushed and sloppy. There were also not 1, not 2, but 3 possible witnesses, and they chose Avery Becker. These accusations are just another defect of the tainted police work. 3, targeted. Avery Becker joined mock trial her freshman year and was looking forward to her senior year on the team. Avery looked forward to potentially winning awards at her upcoming state and regional competitions. Even though Avery was excellent at what she did in mock trial, her and her coach disagreed quite often about Avery's preparation. At regionals in early 2020, Avery won the awards for Best Attorney and Best Closing Award. However, instead of being congratulated for these awards, Avery was instead criticized. And Avery showed throughout her time on the team a natural ability to succeed. Avery deserved recognition for all that she had accomplished. However, after the practice where Brackman criticized Avery stormed out of the building and impulsively she wrote on the top of her coach's car, "Worst Attorney Award," in what she thought was an erasable marker. It was permanent, and Avery, in realizing her mistake, tried to apologize to the coach. But in seeing what she did, Coach Brackman kicked her off of the team. The defense will introduce not one, not two, but 3 witnesses to show you that Avery Becker was not responsible for the murder of her coach, and to show you the holes within the police's investigation and the prosecution's case. This case is as easy as 1, 2, 3. 1, Professor Van Owen will testify to her expertise in crime scene reconstruction and police procedures, providing you with an alternate theory of the case as well as putting forward an alternate suspect. 2, Taylor Perkins, Avery Becker's close friend, peer, and classmate, will testify that she was with Avery Becker all day the day of March 6th looking for Avery's lost phone. And 3, the defendant, our client, Avery Becker. Avery Becker will show you how she wouldn't have committed this crime, and following the devastation of losing her coach, how she could not commit this crime. Today, the prosecution bears the burden of proof, a burden that they will absolutely not be able to meet, as there are too many holes within their case for this to have been met. This case is as easy as 1, 2, 3. At the end of this trial, we will be asking you, the jury, to return a verdict finding our client, Avery Becker, not guilty of her crimes on the charges of first-degree murder and second-degree burglary of a dwelling. This case is as easy as 1, 2, 3. And as you will see at the end of this trial, Avery Becker is not guilty. Thank you.
Thank you, counsel. Prosecution, first witness.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand. Before I begin, can Your Honor see and hear me all right?
Yes, thank you for asking. I can.
Also, at this time, we ask the court to order the defendant to turn on their camera for the first part of our direct examination for purposes of identification, after which she may turn it off again.
Any defense objection? Hearing none, your request is granted, although I don't see anyone on the camera. There she is. Carry on.
Yes, Your Honor. Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Alex Cifuentes, and I'm a senior this year at Colorado High School.
How are you feeling about testifying here today, Ms. Cifuentes?
Nervous? I just want justice for my mock trial coach, Mr. Brackman. It's been really hard knowing that he's gone and that I'd have to tell a jury about what Avery did.
Now, we'll get back to that in a second, but first, could you tell us a little bit about Mr. Brackman?
Well, Mr. Brackman was an incredible attorney and an even better mock trial coach. He seemed to really care about everyone on the team doing their best.
And based on your observations and perceptions, did everyone else on the team have a good relationship with Mr. Brackman?
No, most people liked him, but his relationship with my teammate, Avery Becker, wasn't as great.
How so?
Well, they would argue at almost every practice. Avery didn't do things the way Coach wanted her to, and Coach would call Avery out on it. It got so bad that Avery was kicked off the team 2 separate times.
Do you see the defendant here in court today?
Yes, I do.
Please identify her by an article of clothing and the title of her video.
Yeah, she has black glasses on and a plain white shirt, and the title of her video is Avery.
Your Honor, let the record reflect that the witness has identified the defendant subject to cross-examination.
Record will so reflect.
Also, at this time, the defendant may turn her camera off. Ms. Cifuentes, you mentioned arguments between Ms. Becker and Mr. Brackman. Were there any such arguments in the days leading up to Mr. Brackman's murder?
Yes, there was actually one 3 days before on that Tuesday. They were arguing about the competition that happened that weekend.
Tell us about that.
Well, Coach was telling Avery that she needed to put in more work before the state tournament, and Avery got really upset about this. She grabbed one of the Sharpies that we were using to write down notes with and stormed outside. Later, I found out that she wrote on the coach's car. She was kicked off the team that same night.
And to the best of your knowledge, did Ms. Becker ever attempt to get back on the mock trial team?
She did. She actually texted me and asked if I'd be willing to talk to the coach for her.
Now, I'd like to shift the focus to what happened after Mr. Brackman was murdered. Were you ever asked to come in for an interview by Detective Markowitz?
Yes, I was.
About what specifically?
About the texts that I was just telling you about.
And did you preserve those texts for Detective Markowitz?
I did. Unfortunately, I forgot my phone at home during the interview, but she said that I could send screenshots to her.
Your Honor, let the record reflect that my timekeeper is displaying Exhibit 14 for the jury.
Very well. What's supposed to be happening here? Ah, there we go. All right, thank you. Carry on.
Ms. Cifuentes, what is this exhibit?
These are the texts that I was just telling you about, the screenshots that I sent to Detective Markowitz.
And just to clarify, whose messages are in green and whose are in gray?
The ones in green are the ones that I was sending to Avery, and the ones in gray are the ones that Avery was sending back to me.
And are these texts a fair and accurate depiction of your conversation with the defendant?
Yes, they are.
Your Honor, at this time, I move to admit Exhibit 14 into evidence.
Defense?
Your Honor, I object to this evidence being entered on the grounds of hearsay and on the grounds of best evidence, as while Avery Becker's text messages may be highlighted in this text, Alex Cifuentes are not, also, as well as these are screenshots and not pulled off of the phone directly themselves.
Response?
Yes, Your Honor. These text messages are not hearsay. The statements in gray made by Ms. Becker are statements of a party opponent under Rule 801D2, and the statements made by Ms. Cifuentes are not hearsay because they are not being offered for the truth of the matter asserted, but rather to provide context for Ms. Becker's statements. Furthermore, this is the best evidence pursuant to Rule 1002, as this is an original pursuant to Rule 1001D, which says that an original for electronically stored information, such as text messages, is a printout or any other output readable by sight, which accurately portrays the information. A screenshot is an output readable by sight, and these do accurately portray the information as testified to by Ms. Cifuentes.
May I respond, Your Honor?
Yes.
As Avery Becker's statements are, statements made by a party opponent, we have no objection to those under hearsay. However, Alex Cifuentes' statements, we ask them to be redacted as they are being offered for the truth of the matter asserted. as for best evidence. This is not an original document, and therefore does not meet the requirements of best evidence.
Very well. Regardless of how I might rule in a real trial, for purposes of a mock trial competition, the objection is overruled.
May I publish to the jury?
Yes.
Now, Ms. Fuentes, I'd like to draw your attention to the second text from Ms. Becker. What is this text referencing?
Well, this is Avery telling me that she got kicked off the team and asking if I'd be willing to talk to coach to help her get back.
And how did the conversation proceed from there?
Well, I told her that I wasn't really sure anyone could change the coach's mind, especially after what Avery had done to his car. And that's when Avery showed her true colors.
What do you mean?
Well, she went crazy. As you can see in the very next text.
Objection, Your Honor, cumulative.
Response?
Yes, Your Honor, this is not unduly cumulative pursuant to Rule 403, as Ms. Fuentes is, while Ms. Fuentes is testifying about these texts, it still has probative value to help the jury understand the content of these texts as well as the context surrounding these texts.
May I respond?
Yes.
As she has directly stated that she is reading directly from the text message, I believe that she is wasting the jury's time, as they can read these text messages themselves. They have been entered and published to the jury for themselves to read, and I do not believe that it is necessary for this witness to read directly off of the exhibit.
Understood. The objection will be overruled. Continue.
Ms. Fuentes, were you finished with your answer?
No. As I was saying, she went crazy. She says that if Brackman is still upset about what she did to his car, then he's going to be really upset when he sees what Avery does to his house, to his house.
And did you ever ask the defendant what she meant by this?
Of course. And she told me that she was going to wait until the coach was at work and break in and trash his house.
Thank you, Your Honor. I have no further questions at this time.
Well,
Yes, Your Honor. You know our client, Miss Becker,
Yes, we were teammates.
and you have always been really good friends with Miss Becker.
I thought we were before she killed Mr. Brackman.
The two of you have been on the same mock trial team since freshman year.
Since my freshman year. She's a year older than me. She's actually why I was on the team in the first place.
And you saw Avery as an equal.
Yeah, I thought we were. I mean, her, me, everyone on the team.
Yet considered yourself to work harder than her.
Yes, anyone on the team could see it. She never showed up prepared and was always late.
You even admit to being upset at Avery for coming in unprepared, yet always winning.
Yeah, a little bit. I mean, it's a little disheartening to put in all this work. But then, I mean, we were on the same team, so her success was our success.
You saw.
Here, Mama Counsel, I'm sorry to interrupt. Ms. Fuentes, your volume kind of comes and goes. I'm not sure why that is, but there are times when you fade so that I can almost not hear you. I don't know if that's the case for anyone else, but it is for me. Other counselors saying that it is. So I'm not sure what that's about. I don't know if it's your proximity to the microphone or what, but that's the case. Is there anything you think you can do about it?
I just checked my settings. Is it better now?
I'm afraid not. I can understand what you're saying, but it's very dim, you might say. What microphone are you using? Are you using the one on your computer?
Accidentally, but is it better now that I've switched to my phone?
Yes, very
Okay.
much. Go ahead.
You saw Avery winning awards at your competitions,
Yeah,
and this upset you.
not really upset. I mean, it was a little disheartening, but she was my friend, so it was still exciting for her.
Because it should be you winning the awards.
No, I just think that anyone who puts in more work should be winning awards more than someone who's just charismatic.
In fact, there were multiple instances where you were jealous of Avery's success.
No,
And thought that she was lazy and not a hard worker.
she was not a hard worker. And she was lazy. She barely showed up to practice on time.
You were present when Avery vandalized Mr. Mackenzie Brackman's car.
I wasn't outside with her, but I was at practice, yes.
And this incident resulted in Avery being kicked off of the team.
Yes, for the second time.
Avery's punishment put your team in a really hard place.
Yeah, we were at risk of not being able to go to state. Brackman was doing all he could, but there was no guarantee.
Many of you were extremely upset at her.
Well, yeah.
There was rumor on the team that you and Avery were rivals.
There was a rumor, yeah.
And you wholeheartedly disagree with this statement.
Yes, I do.
You spend a lot of time honing your craft.
Yes, I do.
And you were upset when Avery came in and won all of the awards with her doing no work at all.
Like I said, I wasn't upset. I was just a little disheartened, but she was on my team and she was my friend at one point.
And you think that Avery only won awards not based on her talent, but based off of her appearance?
Talent, not really. Well, work. She had a natural talent. She didn't put in the work, so it was just her charisma and looks, yeah.
And you weren't rivals with Miss Becker, but you thought the team would be better off without her.
I think that any team would be better where everyone puts in the same amount of effort.
And you weren't rivals, but you were excited knowing that you would have a higher place on the team once Avery Becker was gone.
I was excited for, if she graduated, that I might get to have some roles, but that would have happened no matter what.
Moving on, I'd now like to direct your attention to your role in the police's investigation. You were at the Fry Shack the night before the murder and at school the next day.
Yes, I was.
It is your testimony here today that you were at school the next day.
As far as I can remember, yeah. And then I went to mock trial. Brackman didn't show up, and then the team and I went to the Fry Shack.
Your Honor, permission to show the witness what has been marked as their affidavit.
Granted.
My co-counsel will be pulling it up.
I see it.
Ms. Cifuentes, is this your affidavit?
That was the first page.
And at the bottom of this affidavit, once we get there, can you please validate that that is your signature?
Yes, that is.
Now, anywhere within this affidavit, do you state that I was at school the next day?
No, I didn't really find it to be very relevant.
Thank you. Moving on. Co-counsel, you may take down. Detective Markowitz asked you to bring in your cell phone to the police station for an interview.
Yes, she did. And unfortunately, I forgot it.
Because you indicated that there were text messages between you and Avery concerning Coach Brackman.
Yes, there were. I talked about them on my direct.
However, you failed to bring in your phone to the interview with Detective Markowitz.
Yes, unfortunately, I forgot it, and that's my fault.
So the police never had an opportunity to look at the text messages from your phone.
That's not true. I mean, I sent the detective the screenshots.
But never directly from your phone.
The detective never tangibly had my phone, no.
Exhibit 14 is a screenshot of the text messages between you and Avery.
2 screenshots, yes.
And it is in these messages that Avery asks for your help to convince Coach Brackman to let her back on the team.
Yes.
And you said that you would try.
I said I would try, but I wasn't sure that I could change his mind.
And you, in fact, did approach Coach Brackman and make an impassioned plea on behalf of Avery Becker.
Yes.
You then texted Avery and said that Brackman was not going to back down.
As far as I can remember, I think.
And that statement claiming that Brackman was not going to back down is not explicitly in Exhibit 14.
No, after, a couple months of not having that phone and not looking at the screenshots, I guess I kind of just forgot what I said in them.
Because you never turned in your phone to the police for them to pull information off of.
Unfortunately not. I had traded in my phone before I knew that the texts were being questioned.
So Exhibit 4. Sorry, continue.
No, I was just saying I wish I would have known and kept my phone and turned it in.
So Exhibit 14 does not reflect all of the text messages sent between you and Avery Becker.
Yes, it does.
Thank you, Your Honor. No further questions.
Any redirect?
First, may I inquire as to how much time I have remaining?
The prosecution has 18 minutes and 53 seconds remaining.
Yes, Your Honor, briefly. Before I begin, can you see and hear me all right?
Yes, I can.
Ms. Fuentes, did you bear any resentment towards Ms. Becker for her performance in mock trial?
No, of course not. I mean, she was on my team. So her success was our success.
And on cross, you were asked why you didn't put in your affidavit that you were at school on March 6th of 2020. Do you make it a habit to skip school?
No. I work really, really hard in my classes, so I try and never miss a day.
Thank you, Your Honor. I have no further questions at this time.
Very well. May we have the prosecution's next witness?
Your Honor, the prosecution calls Detective Jordan Markowitz to the stand.
Very well.
Before I begin, can you see and hear me all right?
Yes, thank you.
Good afternoon. Would you please introduce yourself to the jury?
Good afternoon. My name is Detective Jordan Markowitz, and I'm a homicide detective with the DPD.
How long have you been involved in law enforcement?
I've been with the DPD for the past 13 years now, 7 of which I've been a detective.
Do you have any unique knowledge or skills that you relied on in your investigation?
Yes, actually. In my investigation, I relied heavily on my knowledge in crime scene investigation, specifically my knowledge in forensic analysis of cell phones and cell data.
Do you have any certifications in this field of cell phones?
I do. I have a certification in call detail records and forensic data recovery from the American Academy of Law Enforcement.
Have you used this knowledge and skill in other cases you've investigated?
Oh, absolutely. All the time. Given how prevalent cell phones and their data are in today's society, I find myself constantly using this type of information.
Your Honor, at this time, I ask that the court recognizes Detective Jordan Markowitz as an expert in crime scene investigation with an emphasis in the forensic analysis of cell phones and call detail records.
The objection from the defense?
No, Your Honor, as long as this witness stays within the confines of her expertise.
Very well, the witness is qualified.
How did you become involved in this case, Detective?
I responded to a request for a detective, and I arrived at the scene at approximately 2:20 p.m.
Could you describe the scene when you first arrived?
Yes. The first thing I took note of was that the door to the residence was open, and the victim was lying face down just inside the doorway, surrounded by a pool of blood. I also took note of a large kitchen knife that was on the ground near the body.
What was the first step in your investigation?
The first step in my investigation was to call in a couple of our teams to help with the crime scene. First, I called in our forensics team, and then I called in Kyle Kuzak, our crime scene reconstructionist.
Since Ms. Kuzak was the one who reconstructed the scene, we'll talk to her more about the details of the crime scene. But what was the next step in your investigation?
The next step in my investigation was to obtain Mackenzie Brackman, the victim in today's case, cell phone. This was to download the contents to see if there might be anything that was relevant to my investigation.
Did you find anything significant on Mr. Brackman's phone?
Yes, actually. I found 2 pieces of evidence that were significant.
Could you tell us about that evidence?
Absolutely. The first piece of evidence I found was that the victim had a Ring doorbell app installed on his phone. And from this app, I was able to download videos of the suspect entering and exiting the residence. And the second piece of evidence I found that was significant was that the victim had recently been in contact with a mock trial team. So that gave me my first lead to follow up on.
Let's start with the Ring doorbell videos. Did you preserve each of those videos for trial today?
Yes, I did.
Your Honor, let the record reflect that my trial technician is displaying exhibits 10 through 13. And at this time, may my trial technician have permission to zoom in on these links so that my witness may properly identify them?
Yes.
Do you recognize these exhibits, Detective Markowitz?
Yes, I do.
What are they?
These are the links to the Ring doorbell videos that I collected from the victim's cell phone.
Are these fair and accurate representations of the Ring doorbell video links?
Yes, they are. I recognize them because I reviewed them prior to trial today.
Your Honor, at this time, I move for the admission of exhibits 10 through 13 into evidence.
Any objection?
None at this time, Your Honor.
Admitted.
Thank you. We can take those down for now and we'll return to them during Ms. Kuzak's testimony. Now, Detective Markowitz, you said there was a second lead on the victim's phone. Could you tell us about that?
Absolutely. Like I was saying, the victim had recently been in contact with a mock trial team, so we reached out to a couple of his students. The first person we reached out to was Alex Cifuentes, and it immediately became clear to me that Ms. Cifuentes had some information that would be pertinent to our investigation today, so I asked her to come on down to the station for an interview.
Did you learn anything significant from that interview?
Yes, I did.
What did you learn?
I learned that Ms. Cifuentes had been in contact with the defendant in today's case, Avery Becker, and they had exchanged several text messages where Avery Becker was claiming to want to break in and trash the victim's home.
Let's bring exhibit 14, which was previously admitted, back up on the screen. Permission to publish to the jury, Your Honor?
Yes.
Now, Detective, earlier we heard Alex Cifuentes talk about these text messages, but how did they impact your investigation?
I'm glad you asked. These text messages really gave us an important window into Avery Becker's reasoning for why she committed this crime. Furthermore, they were consistent with the details we collected at the crime scene, and they really helped to corroborate our theory.
Now, Detective Markowitz, are screenshots an acceptable form of evidence?
Absolutely, yes.
Now, based on the information in these text messages, what was the next step in your investigation?
The next step in my investigation was to reach out to Avery Becker to see if we could get access to her cell phone, not only to confirm the validity of these texts, but also to gain knowledge about her whereabouts on the day in question.
Were you able to get access to Avery Becker's cell phone?
Unfortunately, no. We were informed that it was no longer in her possession.
So without the cell phone, what could you do instead?
Well, I subpoenaed for Avery Becker's call detail records. We'll call them CDRs for short.
What is a call detail record, Detective?
A CDR tells me the location of a cell tower that a person's phone connects to at any given point when they receive a digital communication. Now, this is such as a call or a text. And based on that information, I can compile that data to tell people's basic whereabouts.
Were you able, using call detail records, were you able to figure out where the defendant was at the time of the homicide?
I was actually. There were 2 maps that were prepared that would be helpful for the jury to visualize what all of this really means.
Your Honor, let the record reflect that my trial technician is displaying exhibits 15 and 16 on the screen.
Very well.
Do you recognize these exhibits, Detective Markowitz?
Yes, I do.
What are they?
These are, Exhibit 15 is the map that I was talking about that I compiled based on Avery Becker's call detail records for the time in question. And Exhibit 16 is that same map, but it has a potential route that the defendant could have taken to get to the victim's home.
Are these fair and accurate representations of the defendant's location based on the data you collected?
Yes, they are.
Your Honor, at this time, I move to admit exhibits 15 and 16 into evidence.
Any objection?
None at this time, Your Honor.
Admitted.
Permission to publish to the jury, Your Honor?
Granted.
Now, Detective, using exhibits 15 and 16, could you explain to the jury the route that matches both the time and location of the defendant's phone on the day in question?
Absolutely. As you can see, the defendant's phone begins in the top quadrant that is highlighted by that shaded region in the upper part of the exhibit. It pings that first tower 2 times before moving down to a tower between the defendant's home and the victim's home. It pings this tower once, and then finally it ends up at the bottom tower, as you can see in the bottom left-hand corner of both exhibits. And this is where the defendant's home, the victim's home is in today's case. And it pings here 4 times.
So what does all this mean?
To a reasonable degree of scientific certainty, this means that the defendant's phone was at the victim's home for approximately 12 minutes during the time that the crime took place.
Thank you. The exhibits are no longer needed. Now, Detective Markowitz, based on your investigation and in your expert opinion, was Avery Becker involved in the break-in that led to the death of Mackenzie Brackman?
Yes. Based on my investigation and in my expert opinion, Avery Becker went to Mackenzie Brackman's home to trash it, and during the course of that intrusion, Mr. Brackman was killed by Miss Becker.
Thank you, Your Honor. I have no further questions.
Ross?
Yes, Your Honor. Detective, you took photos of the crime scene once you arrived, correct?
Yes, I did.
Your Honor, at this time I ask permission to show the witness what has been marked as exhibits 1, 4, 5, and 6.
Granted.
And Detective, these are the photos that you and your team took at Mackenzie Brockman's residence.
1, 4, and 5 are. However, 6 was actually taken at the lab afterwards, and I did not take that photo.
But your team took that photo, right?
Yes,
And you
that's
recognized
correct.
it.
I do, yes.
And are these fair and accurate representations?
They are.
Your Honor, I move for the admittance of exhibits 1, 4, 5, and 6.
Any objection?
I have no objection, Your Honor.
Admitted.
Your Honor, I move to publish.
Granted.
Now, Detective, let's look at exhibit 1, and my co-counsel is going to zoom in more on Mackenzie Brockman's right hand. Can you see the hand all right?
Yes, I can.
And that hand is above Mackenzie Brockman's head.
It is, yes.
Now let's move over to exhibit 4. And these photos were taken around roughly the same time.
They were.
Now, can you see Mackenzie Brockman's right hand in this photo?
Yes, I can.
It is to the right of his head.
Yes, we actually moved it to get a better angle of the stab wound in this case.
But you did move the body.
Yes, this is common practice.
All right, and now let's go to exhibit 5 for me, please. And my co-counsel is going to zoom in on a logo here. Can you see that logo fairly well?
Not really, no. My apologies.
But can you make out the letters O, R, and Y on the side?
Yes, I believe I can.
Now let's move over to Exhibit 6, which is, this is the exact same knife that your team photographed in the forensic lab, correct?
Yes.
Now let's look over in that exact same area where that O, R, and Y were. Those are not present on this knife.
I'm sorry, I cannot tell you for sure, as I did not take these photos, but it doesn't appear that they are present on this side of the knife.
But these are in the same exact orientation as before.
It is possible that the photo is mirrored or flipped. I couldn't tell you for sure.
But from your observations of this photo, none of that logo is there on that knife.
It's not present in this photo, no.
So they aren't the exact same knife in each photo.
I would disagree with that. This is the same knife we collected from the crime scene.
Let's move on to your call detail records that you collected of my client's cell phone. You were able to get a warrant for my client's call detail records.
That is correct. I subpoenaed for her call detail records, actually.
And now let's look at the diagram, Exhibit 15. Could you reference that diagram for me, please? I'm going to have my co-counsel pull that exhibit up for me. And we're going to zoom in around the first tower, if that's all right with you.
Of course.
And on this map, you have a few notable locations on this map, right?
Yes, that is correct.
Including Blair Rowland's residence.
Yes, Blair Rowland's house was within the first sector.
But you never personally investigated Blair Rowland's.
Ultimately, the facts of the case did not lead to Rowland's, so I wouldn't want to waste needless police hours.
Yet you wasted needless police hours by putting his house on the map.
That took potentially 15 seconds, counsel. I don't think that's needless police work.
And in your investigation, you thought it was important enough to note it on the map.
Yes.
Now, looking at your ideal route, you believe my client took Rock Creek Parkway to Mackenzie Brockman's residence at the bottom of your diagram.
That's one potential route he could have taken, yes.
And Blair Rowland's house and Avery Becker's house are near each other, right? Roughly in the same area?
They are roughly in the same area, yes.
Then wouldn't you agree with me that Blair Rowland's ideal route would be to Mackenzie Brockman's residence would be via Rock Creek Parkway?
I suppose if Rollins had committed the crime, that would be the route, but the facts of the case do not support that.
Now, let's talk about the type of call detail records that you received. Call detail records are only an approximation of where a cell phone is.
That is correct to a certain degree.
It cannot pinpoint directly and precisely where a phone is.
No, as you can see, it encompasses a certain shaded region as pictured in my maps and as I mentioned previously.
And phones don't always connect to the nearest cell phone tower.
Not always, no.
Meaning that someone's cell phone tower could connect to a farther away tower when they aren't even near that tower.
That is a possibility, yes.
Meaning that if Avery Becker's phone was connected to the higher tower up top or the middle tower, it could connect to the tower nearest Mackenzie Brockman's residence.
That would be possible if it only pinged the tower once. However, as you can see in the map, it pings the tower 4 times, which means that the phone was within that area.
And detective, these call detail records only detail where a cell phone's approximate location would be.
I'm sorry, I don't think I understand your question.
That these call detail records are only pinpointing a cell phone, right?
That is correct.
It does not detail whether someone was with their cell phone.
The call detail records do not. However, the facts of the case do support the fact that Avery Becker was in possession of her cell phone at this time.
But on your reliance, as you stated in your direct examination, that you relied on these to pinpoint my client to Mackenzie Brockman's residence, these call detail records cannot prove Avery Becker was with her phone.
Again, the call detail records alone cannot, but the entirety of the case does point to Avery Becker.
But call detail records cannot pinpoint where my client was with respect to her cell phone.
As I said, the call detail records alone cannot.
Thank you, Your Honor. I have no further questions.
Very well, redirect.
Before I answer that, may I inquire as to how much time I have remaining?
The prosecution has 8 minutes and 29 seconds remaining.
A very brief redirect, Your Honor. Detective Markowitz, who does the evidence point to in this case?
Everything points to Avery Becker committing this crime.
Does any of the evidence point to Blair Rollins being involved?
No.
Thank you, Your Honor. I have no further questions.
Very well. May we have the prosecution's next witness?
Yes, Your Honor. The prosecution calls Kyle Kuzak to the stand.
Very well.
And may I have a moment to rearrange my virtual courtroom?
Yes.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Kyle Kuzak. I am a crime scene reconstructionist for the Denver Police Department. I'm commonly referred to as a CSR for short.
A few minutes ago, Detective Markowitz established the different roles law enforcement had in this investigation. What was your role as the crime scene reconstructionist in this case?
My role was to work with the forensic team to determine how Mackenzie Brackman's death occurred. And my job is to piece all of the evidence together in order to determine how this crime occurred.
How long have you been involved in the field of crime scene reconstruction?
For approximately 19 years now. My specialty is complex crime scenes that range from homicides, burglaries, armed robberies, and many more.
Are you certified to do what you do?
I am. I'm certified under the Colorado Bureau of Investigation.
And without telling us what that expert opinion is, have you reached a conclusion in today's case that would be helpful for the jury?
I have.
Your Honor, at this time, I ask that the court recognizes Ms. Kyle Kuzak as an expert in crime scene reconstruction and investigation.
Any objection?
No objection at this time, Your Honor. I just ask that the witness stay within her scope of her expertise.
Very well. The witness is qualified.
Yes, Your Honor. Ms. Kuzak, how did you first approach your crime scene reconstruction in this case?
As a CSR, my job is to come to the most scientifically sound conclusions when reconstructing a crime scene. So to that end, I always follow a 5-step analysis process, which allows me to memorialize and document as much information and evidence as possible to come to the best reconstruction I can, given the evidence found.
And what evidence did you rely on to formulate your conclusions?
For this case, I looked at all of the photographs that are included in the case file, all 4 Ring doorbell security system videos, police reports, and the autopsy report. I also visited the scene of the homicide.
Let the record reflect that my child technician is displaying what has been previously marked as exhibits 1 through 9, as well as exhibit 18. Ms. Kuzak, I know opposing counsel admitted exhibits 1, 2, 4, 5, and 6. So, excuse me, 1, 4, 5, and 6. So let's talk about exhibits 2, 3, 7, 8, and 9, as well as exhibit 18. What are those?
Well, photographs or exhibits 1 through 4 are all pictures of the victim. Exhibit 5, which has already been admitted, and 6 are just photographs of the knife in different settings. And therefore, exhibits 7 through 9 are all pictures that were taken in the victim's kitchen. And exhibit 18 are photographs of the scuff marks at the rear door.
And are these all accurate depictions of the crime scene that you personally saw?
Yes, they all are.
Your Honor, I move to admit exhibits 1 through 9 as well as exhibit 18 into evidence, excluding the exhibits already admitted by opposing counsel.
Any objection?
No objection at this time, Your Honor.
They are admitted.
Your Honor, permission to publish Exhibits 1 through 9, Exhibit 18, as well as Exhibits 10 through 13, which were admitted on the direct examination of Detective Markowitz.
Granted.
Now, let's start off by talking about Exhibits 10 through 12. May I publish Exhibit 10 for the jury?
Yes.
Let's play this exhibit for them. And now let's play Exhibits 11, and after that, let's play Exhibit 12, please. And finally, Exhibit 12. Ms. Kuzak, can you briefly explain what we just saw in these three videos?
Of course. We just saw the perpetrator approach the victim's front door, which was locked. Therefore, the perpetrator proceeded to the south side of the residence, opened the rear fence gate, proceeded into the backyard, and after that, in Exhibit 12, we see the defendant open the sliding glass door and enter the victim's residence.
Now, let's display Exhibits 8, 9, and 18. Using these exhibits, can you briefly explain what happened after the intruder entered the residence?
Because the intruder entered through the rear door, Mr. Brackman was notified through the Ring doorbell security system. Therefore, he armed himself with a knife that came from the kitchen knife holder pictured in Exhibit 8 to the left of your screen. Therefore, a struggle between the two ensued. The struggle moved from the rear door to near the kitchen table where the plate was knocked down, as we can see in Exhibit 9. And therefore, at some point, the perpetrator disarmed Mr. Brackman and stabbed him in the scapula area.
Now, let's play Exhibit 13, and at the end of that, let's display Exhibits 1, 2, and 5. Ms. Kuzak, based on these evidence, is the evidence you analyzed consistent with Avery Becker committing this crime?
Yes. The evidence found at the crime scene directly points to the motive that Detective Markowitz described to us a few moments ago. There is clear correlation that Avery Becker was involved in this crime scene, and as we saw, Avery Becker matches the general height and build of that perpetrator seen in the Ring doorbell videos.
Thank you, Your Honor. Thank you, Ms. Kuzak. I have no further questions at this time.
That's examination.
Yes, Your Honor. Mrs. Kuzak, you made a witness tracking spreadsheet for this investigation?
I did, yes.
Your Honor, if I may show the witness what has been marked as Exhibit 17.
Yes.
Do you know what this is, Ms. Kuzak?
Yes, however, there's another page to my report. There is a third page.
There should be a timeline, yes?
Yes, a rudimentary flow chart.
I don't know if it's on this exact, or Your Honor, we're having technical difficulties. I don't believe that it was on that same exact like slideshow that we have. So I'll can I move on while my counselor is bringing up the exhibit, or do you want me to wait?
Oh, you can go ahead.
Ms. Kuzak, do you know what that is?
Yes, that was part of my report.
And is it a fair and accurate representation of your report, except for the timeline?
Yes, except for the rudimentary flowchart.
And is this witness tracking spreadsheet a regularly conducted activity?
It is, yes.
There's your flow chart. And do you make one for every investigation?
Yes, it's part of my 5-step analysis in the documentation and memorialization process.
And you made one for this investigation, of course.
I did. It would be Exhibit 17 on the screen.
And you made this with all knowledge of events, evidence, and facts of the investigation?
Yes, all facts that were relevant at the time of my report.
Your Honor, I move to admit Exhibit 17 into evidence.
Any objection?
No, Your Honor. If opposing counsel would like to admit this piece of evidence, they can do so.
Your Honor, I would also move to publish.
Let me hear that again from.
Your Honor, I have no objection.
Very well. Admitted.
Your Honor, I move to publish this exhibit as well.
You may.
The letter S on this document, Ms. Kuzak, means suspect, correct?
That is correct.
And you list not one, not two, but 3 suspects on this document.
Yes, to my understanding, there was 3 initial suspects. However, given the rest of the evidence considered, some of them were discarded.
You list Avery Becker.
Yes, as a first suspect.
You list Alex as well, Alex Cifuentes.
That is correct.
You also list Blair Rollins.
Also correct, which is in line with what Detective Markowitz said.
And you have Alex's name spelled incorrectly on this form as well.
Yes, I think that was a typo just from my behalf.
And moving to the crime scene, you went there, correct?
I did.
You mentioned scuff marks, but there's no way to tell when they occurred, correct?
The scuff marks alone cannot be carbon dated. However, given the rest of the evidence that was found within the home, they can be put in the specific timeline, which is this crime scene specifically.
So that's a yes, they cannot be dated.
Not the scuff marks alone.
And you believe that the victim was alerted by a Ring doorbell camera?
Yes, that is correct.
But there's no way to tell if he was alerted by the Ring doorbell camera.
The Ring doorbell security system is designed to notify of the whereabouts or surroundings of one's home. Therefore, that is the purpose of the Ring doorbell system.
And you didn't find any DNA evidence other than the victims?
That is correct. That is because
And
the
meaning
perpetrator, as we see in the video, is wearing gloves.
Objection, Your Honor, objection, Your Honor, non-responsive. I would like the witness to confine to a yes or no question. That is what I am asking.
May I respond, Your Honor?
Yes, go ahead.
Opposing counsel did not phrase a perfectly phrase yes or no question in their cross question and then proceeded to cut off my witness during her answer. Opposing counsel has not laid any foundation that that was in fact a properly framed yes or no question, and therefore it's not non-responsive.
Your Honor, if I may, I asked, and you didn't find any DNA evidence other than the victims. That is a yes or no question. There is no extra response needed in order to make that question make sense.
Well, I think your objection can be sustained, but can't change what's happened, so go ahead.
Yes, Your Honor. Meaning you don't have any DNA evidence.
That is correct.
And the intruder was wearing a mask,
Yes, and gloves.
which means you can't tell who the intruder was.
No, there are no distinctive characteristics other than height.
And all you really have is a generalized height and build.
Yes, which is a signifying
Further questions at
characteristic,
this time,
counsel.
Your Honor.
Objection, Your Honor, may be heard.
Yes,
Opposing counsel cut off my witness during the finishing of her answer. I ask that my witness be allowed to finish. As this is opposing counsel's last question, it's important for Ms. Cusack to have the opportunity to finish.
response.
Your Honor, I believe she answered my question. All I asked was, you really only have a generalized height and build for the suspect? And she answered yes, starting her question, and that is the only answer that
He's frozen a little bit, counsel, I think.
Sorry.
You're
Sorry, my internet connection is going out a little bit. Can you hear me clearly now?
Yes, you're fine now.
So I said that my question was, can you hear me? Sorry.
Off and on, I think, counsel.
Yes. So I asked if you really only had a generalized height and build for the suspect, and she started with the answer of yes, and then went into more explanation. But I don't believe my question was asking for much more than just a yes or no. I don't believe there was any explanation needed in order to finish my question.
All right. I understand. I will sustain the objection. And
Your Honor, I ask that my witness be allowed to finish her answer.
all right, go ahead.
As I was stating earlier, height is a signifying characteristic in this instance.
Very well.
No further questions at this time, Your Honor.
All right. Anything further of this witness?
May I inquire as to how much time I have remaining?
The prosecution has 30 seconds remaining.
I'll conduct a brief redirect, Your Honor. May I have a moment to rearrange my virtual courtroom?
Yes.
Ms. Cusack, how did the Ring doorbell system aid you in your understanding of events?
The Ring doorbell system notified Mr. Brackman of the intruder. That is why he armed himself with a knife.
And how do you know it was Avery Becker in that mask?
We have the general height and build of the perpetrator, which is Avery Becker's height. And we also have the CDR data and cell tower analysis that Detective Markowitz talked about.
Thank you, Your Honor. I have no further questions. And at this time, the prosecution rests.
Very good. I reckon we can go ahead with the defense witness number one.
Your Honor, the defense calls Professor Blake Van Owen to the stand.
All right. Go ahead.
Okay, please state your name and spell it for the record.
Blake Van Owen, Van, V-A-N, Owen, O-W-E-N.
And Miss Owen, what is your occupation?
Currently, I work as a private investigator and a professor.
Do you have any other job experience?
Previously, I was employed with the Aurora Police Department. I've also worked as a school resource officer and a private security guard, and I now currently work as a private investigator.
What education have you completed in your field?
I first obtained my bachelor's degree in 2005 from the University of Colorado Boulder, and then I obtained my master's of criminal justice at Ashford University's online program.
And what training have you completed?
My out of classroom experience started at the Aurora Police Department as a law enforcement officer. After that, I taught a class on police procedures at Community College of the Rockies. And for the last 5 years, I've been teaching a class on police practices and social justice at CU Denver.
Have you ever previously testified in court?
I've testified as an expert in a number of US district and state courts, such as in the states of Colorado, Kansas, Arizona, Wyoming, Nebraska, and New Mexico, providing my expert opinion 25 times and consulting in over 100 cases.
And what fields have you testified in as an expert witness?
I've testified as an expert in 3 areas multiple times, those being crime scene reconstruction 8 times, cell tower data analysis 5 times, and general police practices 12 times.
Your Honor, at this time, we ask that this witness be entered as an expert in police procedures with an emphasis on crime scene reconstruction and cell tower analysis pursuant to Rule 702 as they meet the requirements of training, experience, and education.
Is there a prosecution objection?
Your Honor, the people maintain that this witness does not have the qualifications necessary to opine in the broad field she's been tendered in. However, given the fact that she's been recognized as an expert by other courts, we will not object to her admission as an expert and will rather explore her concerning lack of qualifications on cross-examination.
All right. Any response?
Your Honor, I believe that as they are not objecting to my witness being entered in as an expert, that is more than okay, but also my witness has showed her experience, her training, and her education sufficiently to the court, and I believe that the jury can reflect that in her testimony here today.
Very well, the witness is qualified. Go ahead.
Why are you here in court today, Professor Van Owen?
Well, I'm here to testify on behalf of the defense as someone with knowledge of police practices and my time as a private investigator who's consulted on this particular case.
And how did you get involved with this case?
I was hired to investigate on behalf of the defendant, Avery Becker, and the potential holes in the prosecution's case.
What fields were you asked to testify to?
I was asked to give the opinions on 3 things. First, that Mr. Brackman was not guaranteed to have been stabbed in a struggle. Second, to establish that Avery Becker's phone was not at the crime scene and neither was Avery Becker. And third, finally, to establish that the prosecution's case is not methodologically sound.
What materials did you review in order to create your conclusion?
I reviewed 3 areas. 1, the crime scene investigation, as well as the cell tower data and the police reports.
And what are your opinions regarding those reports given by Detective Markowitz and Kyle Kuzak?
After reviewing the materials provided by Detective Markowitz and Kyle Kuzak, such as the crime scene investigation, the cell tower data, and the police reports, I felt the need to conduct an investigation of my own.
And why do you believe that you needed to conduct that investigation?
Well, it was unfortunate that the materials given to me were haphazardly conducted. As a result, the prosecution missed a lot of information that I expanded on in my investigation. You cannot call it evidence if it's solely based on assumptions.
And in your personal investigation, what material did you review?
I covered areas such as the murder weapon, the method of killing, the cell tower data, and investigated the prosecution's overall case.
And in your expert opinion, how was Mr. Brackman most likely killed?
Well, rather than any kind of struggle, it's most likely that Brackman was killed while sitting down.
Why do you believe this to be true?
Well, according to my findings, the position of the knife would have had to have been very specific for it to have pierced through the scapula and nicked the aorta, which was the cause of death noted. Also, the person who would have had to have stabbed Brackman would have had to have done so most likely from behind and have been of a much larger build than Brackman. And if both of these have proved to be true, it would explain what to look for in a murder suspect.
Would it be possible for someone of a similar build to have overtaken the victim?
No, the assailant, like I said, would have to be of a much larger stature to have been able to stab Mr. Brackman from a downward angle while standing. And this is demonstrated in the report that I conducted. This all made the possibility of a struggle very uncertain and not likely the scenario.
And how would the victim have had prior notice to being attacked?
In reality, Mr. Brackman wouldn't have known. I know that there's a possibility of the Ring doorbell notifying and giving Mr. Brackman a warning that someone was approaching his house. However, there is no tangible evidence that states that Brackman had received a notification. The prosecution did not obtain the complete records that would have proven this fact true.
I'd now like to discuss some information about cell phone towers. What is the coverage of an average urban cell phone tower?
In an urban area, a cell tower roughly covers a circular area of about a 6 to 7 mile radius.
And how can you identify where a phone was located inside of that sector?
So each sector represents an antenna on the cell tower. And by identifying the sector, it's possible to identify where within the sector the phone could have been based on the multiple antennas.
Is this method of location always reliable?
In reality, cell phones don't always connect to the nearest tower. For example, if there's a heavier cellular usage at the time, the phone may connect to a less busy tower that's further away. So the data is not always precise.
And in your expert opinion, what is the possibility of Avery being within the radius of Brackman's home according to these cell phone tower records?
So if Avery's phone had pinged off of the cell tower near the victim's house, it's no guarantee that she was in the victim's house because her phone was connected to the nearest tower. There's no way to tell the exact location of Becker to say whether or not she was in the victim's home.
Could you please, for the jury, review why you conducted your own investigation? What specifically motivated you to conduct your own research?
There were so many aspects of the prosecution's case that had been rushed and they had failed to pay attention to. Instead, they came up with the theory based off of incomplete evidence.
You mentioned incomplete evidence. What are you referring to?
Well, first, the pictures of the blood drops in the hallway and the cast off near the front door. Apparently, the image files of those were corrupted. And not only that, but the investigation from the prosecution's witness, Detective Markowitz, on the cell phone tower records, she had only obtained the records for a limited window instead of a full picture of the day.
And what is your opinion on the screenshots from Alex Cifuentes?
I'm surprised that these screenshots were even accepted and used in the building of the case, instead of obtaining the phone with the actual messages on it. Their investigation accepted screenshots that easily could have been doctored. Obviously, this was a matter of what was convenient to them at the time instead of providing any actual evidence to their investigation.
And is this a normal procedure used in policing?
No, it's not. The police have special hardware for this purpose. The Denver police specifically use Celebrite, and I'm quite sure Detective Markowitz mentioned how they had downloaded the contents off of Mr. Brackman's phone as well. So Celebrite is like I said, is a software that downloads contents off of phones. So since these screenshots could have been altered in any manner, if really finding the murderer was their real motive, they would have subpoenaed the phone and downloaded the information needed.
In your opinion, did Avery Becker kill Mackenzie Brackman?
No, the evidence doesn't line up for Avery to have been the one to kill Mackenzie Brackman. In my opinion, more evidence leads to Blair Rollins to have committed the murder.
Who is Blair Rollins?
Blair Rollins is the child of Jonathan Rollins, who was actually a former client of Mr. Brackman.
And why do you believe that it was Blair Rollins?
Well, one, I believe that Blair has a stronger motive to kill Brackman than Avery, since Mr. Brackman was the reason that their father was put into prison and given a life sentence. And two, on the day of the murder, Blair wasn't at school.
And what factors did you rely upon in making that decision?
Well, it's easy as 1, 2, 3. To start, Avery is a victim of circumstance. There are far too many discrepancies within this case to narrow it down to just one suspect. There's absolutely no confirmation tying Avery Becker to the death of Mackenzie Brackman. There are far too many holes in the prosecution's case. 1, we cannot pin Avery's phone to just one cell tower. 2, there were too many overlooked suspects. 3, and finally, there's no DNA evidence. There's no face to the perpetrator. There's only a generalized height and build for the suspect. There's no way to say that there was only one suspect, and specifically that it could be Avery.
Thank you, Your Honor. No further questions at this time.
Sorry, I was muted. Cross-examination.
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
Yes, go ahead.
Before I begin, can Your Honor see and hear me all right?
I can, yes.
Professor Van Owen, you said there's no evidence of a struggle at the crime scene. Is that right?
Yes.
There were scuff marks found near the door, weren't there?
Yes, there were scuff marks, but that doesn't prove anything.
So that's a yes, there were scuff marks.
Yes.
And there was a chair found tipped over.
Yes, there was a chair found tipped over.
And there was also a broken plate found on the ground.
Yes, that is correct.
Based on your analysis, you agree a burglary occurred, don't you?
Yes.
And you agree that Mr. Brackman died during the course of that burglary?
Yes.
Now, I'd like to talk about some of the things you agree with Ms. Kuzak on. You agree with Ms. Kuzak that the description of the blood droplets is consistent with the victim moving towards the front door with the knife lodged in his back. Is that accurate?
Yes.
And you agree that the cast off would have been caused when the victim pulled the knife out of his own back?
Yes.
And you agree that, you agree that the knife would have been creating a plug in the victim's aorta?
Yes.
And that when he pulled the knife out, he would have bled to death rapidly?
Yes, that's a very fatal wound.
Where we disagree is about who committed this crime. Is that fair to say?
Yes, that's fair.
And you agree that Avery Becker was absent from school on March 6th of 2020, don't you?
Yes, I do.
And Alex Cifuentes was in school, according to the records.
Yes, that is correct.
You also agree that Avery Becker matches the height and build of the intruder on the Ring doorbell videos.
Yes, but also Blair Rollins matches the height of Avery.
Thank you. I wasn't asking about Blair Rollins. Yes, Avery Becker matches the height and build of the intruder.
Yes, I said that.
And you agree that the cell tower records place Avery Becker's phone near the victim's residence at the time of the murder.
The phone was described in the area, but that does not prove that Avery was there.
So that's a yes to my question.
Yes.
Now, you make a decent living revealing where the police have dropped the ball. You've said that, right?
Yes, when you've worked in the profession, you know what to look for.
And you like to think of yourself as a check on the power of police?
Yes, every power needs check.
And you worked as a police officer for 9 months back in 2005, is that right?
Correct.
And during that time, you've never mentioned investigating burglaries or homicides in that role, did you?
No, I did not mention that.
And next, you worked as a school resource officer, is that right?
Correct.
And you never mentioned investigating burglaries or homicides in that role either?
No, I did not.
And next, you worked as a private security guard, is that right?
Correct.
And you never mentioned investigating burglaries or homicides in that role?
No, I did not.
Then you became a private investigator and a professor?
Correct.
This was in 2015. Do I have that right?
Yes.
So you've been testifying as an expert in this field for about 6 years now?
Yes.
And during that time, you've only testified for the defense?
Yes, that is correct.
Now, you would agree that there were a lot of different members of law enforcement involved in this case, wouldn't you?
I would.
And with all the different members of law enforcement, hundreds of hours were spent investigating this case.
Yes, true.
You say this investigation was rushed, don't you?
I did.
When you're rushed, you miss things. Your words?
Yes.
By the way, you charge the defense $225 per hour for any investigation work. Is that right?
Yes, this is a job that I do. I would since that I charge.
And you charge them $450 for court deposition and testimony.
Objection, Your Honor. Relevance?
May I respond, Your Honor?
Yes, go ahead.
This is relevant pursuant to Rule 401, and it is proper cross-examination into the bias and credibility of the witness. This witness has claimed that she's conducted an intensive investigation into this case, and this is going in to show how she did not, in fact, conduct a proper investigation into what she claimed she did.
May I respond?
Yes, go ahead.
I do not believe that my witness testifying to her salary that anyone who has a job makes is relevant at all to the credibility of this case, as anyone who works has a job, anyone who works gets paid, and that I do not believe that this goes into show bias at all.
May I respond, Your Honor?
Very well.
Once again, Your Honor, I'm not offering this to show that this witness is biased. Rather, I'm offering it to show her credibility in this case, as she's testified that she conducted an investigation into this matter, and I'm simply questioning the credibility of that investigation.
Right. I'm going to go ahead and allow the question. Proceed.
So that's a yes to my question. You charge $450 per hour for court deposition and testimony.
Yes.
And so far, you've charged just under $7,000 for your investigation.
Yes.
And you anticipate charging at least another $1,000 more for your testimony today.
Yes, that's correct.
Your Honor, at this time, I have no further questions. However, pursuant to Rule 201, I ask the court take judicial notice that $7,000 divided by $225 per hour is 31.1 hours spent on this case.
The court takes notice of that.
And with that, I'm finished.
A brief redirect.
Go ahead.
How reliable are the scuff marks that were found at the scene of the crime?
They're not reliable at all. We don't know or have any way to test when the scuff marks were made.
And from the prosecution, were there any photo evidence of the blood spatter at the scene?
No, those were lost and the image files were corrupted.
Could you elaborate slightly on Blair Rollins and their similarities in height and build to Avery Becker?
Yes. So Avery and Blair Rollins were often mistaken from behind because they look so similar.
What work do you do?
Well, I've done a lot of work, but like I said, now private investigating.
And is it normal for you to get paid for this job?
Yes. The
In fact,
majority of jobs people do get paid for.
thank you, Your Honor. No further questions.
Very well. May we have the next witness?
Your Honor, at this time, the defense would like to call Taylor Perkins to the stand.
All right.
I can't see opposing counsel as of right now.
I can't either, but I'm sure he or she can hear us, so go ahead.
Please state your name and spell the last, Mr. Perkins.
My name is Taylor Perkins. That's spelled Perkins.
And can you tell me how you know Avery Becker?
Avery Becker is my best friend, and I can't believe it's come to me having to testify for her against killing Mr. Brackman. There's no way she could have done this. We were together the whole day. Avery wouldn't have, and she couldn't have killed Mr. Brackman.
And why can't you believe she's being held on trial?
Like I said, we were together the entire day, and Avery is a teenage girl. Mr. Brackman is a grown man. Put those together, it doesn't make sense. There's no way she could have killed him.
I know that this is hard for you, but I want to talk about the events on March 6th, or March 5th, sorry, the night before the murder, if that's okay with you. Where were you?
Well, Avery and I were at our house playing video games on our phones, and then we decided to go to the Fry Shack, where all the mock trial students like to go.
Can you tell me who was at the Fry Shack?
Honestly, everybody was there. The entire mock trial team, and even Alex Cifuentes.
And who is Alex Cifuentes?
Alex is a student on our mock trial team, but she never really got along with Avery. It's like she was jealous of her skills or something.
And tell me what happened at the Fry Shack.
Well, Avery must have gotten pretty upset because she stormed off to the bathroom, leaving her phone on the table. Avery never forgets her phone. It's like it's joined to her hip. But once we came back, we left the Fry Shack.
And who was there when you guys were leaving?
Unsurprisingly, Alex was still at the table, sitting down.
Moving to March 6th, the day of the murder, can you explain what you were doing on that morning?
Well, Avery came by to pick me up for school, which was normally occurred because we rode to school together all the time. But that's when we realized that her phone was missing.
And what did you guys do after realizing her phone was gone?
Well, we looked everywhere. We couldn't find it though, but we looked to the Fry Shack, we went to the mall, and really any other place we went the night before.
And did you guys ever find her phone?
Like I said, no, it's still missing to this day.
Taylor, I want you to think hard and try and remember the last place you remember seeing Avery's phone.
Well, I saw it at the Fry Shack on the table where Alex was sitting down.
You also earlier talked about how you spent March 6th with Avery, but what does that mean?
Well, we were together the entire day and we looked for her phone the whole time. But it was like from when school was starting to when mock trial practice was starting.
And finally, as someone who's known Avery and been very close with her, what are your thoughts about all of this?
It honestly just sickens me that my best friend is facing prison for something that she could have never done. Like I said many times, we were together the entire day looking for her phone, but we never found it, and we were nowhere near Mr. Brackman. I just can't believe he's actually gone.
No further questions at this time, Your Honor.
All right. Ross?
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
You may.
Your Honor, sometimes my camera takes a moment to load. And Your Honor, before I begin, can you see and hear me all right?
Yes, indeed. Go ahead.
Now, Mr. Perkins, I'd like to talk about the map Detective Markowitz talked about earlier. Your Honor, permission to publish Exhibit 15 for the jury?
Granted.
Now, Mr. Perkins, you saw this map earlier today, yes?
I did.
And you heard Detective Markowitz testify to the map or cell towers placing Avery's phone at the scene of the crime. Am I remembering that correctly?
Yes, I remember hearing that.
And when you look at this map, that's Avery Becker's home in the top shaded region, yes?
Yes, it is.
And if you look in the bottom shaded region, that's Mr. Brackman's home.
Yes.
And earlier on direct examination, you testified to being with the defendant at the frat shack and the mall. Is that correct?
Yes, I did say that because that's
But neither the frat shack nor the mall are in any of the red shaded regions, are they?
They're not.
Thank you. That exhibit is no longer needed. Now, we've talked about the map. Let's talk about the messages. Your Honor, permission to publish Exhibit 14 for the jury?
Granted.
Now, Mr. Perkins, it's true that after Avery Becker was kicked off the team, the two of you thought of ways for her to get back on,
Yes.
and that included texting everyone on the team. Is that true?
Yes, it did.
You even think she texted Alex Fuentes. Isn't that also true?
Yes.
Now, when you look at this text message, that's Avery's name and the contact information, correct?
Yes.
And the person labeled first says, "Hey, Alex, it's Avery." Am I reading that correctly?
Yes, you are.
And just like you thought, the text message chain shows Avery Becker asking for help to get back on the mock trial team. Yes or no?
Objection, Your Honor, cumulative.
I'll allow it. Go ahead.
So that's a yes to my question. That's what the text message chain says.
Yes, it says that.
Thank you, Your Honor. This exhibit is no longer needed. Now we've talked about the map. We've talked about the messages. Let's talk about the motive. Mr. Brackman and Avery Becker had a feud, correct?
They did.
And the feud bothered the defendant.
It did.
The defendant even played pranks on Mr. Brackman, didn't she?
She did.
Objection, Your Honor, relevance.
Response.
Your Honor, this goes to the motive of Avery Becker, as it's the prosecution's theory in today's case that it was Avery Becker who had motive to commit this crime. This is also proper cross-examination into the bias and credibility of the witness. As on direct examination, Mr. Perkins testified that Avery Becker had no reason to commit this crime. I'm simply using this line of testimony to challenge that testimony today.
Your Honor, if I may, I believe that this is a crime of burglary and a murder, and I don't believe harmless pranks have anything to do with a murder or a burglary.
I understand your objection, but for purposes of the competition, I will allow it. Go ahead.
So that's a yes to my question.
Yes.
But you would agree that the defendant, or excuse me, that Mr. Brackman was mean to the defendant?
Yes. He even said that she didn't deserve her award sometime, which is really not a nice thing to say.
That's right. Mr. Brackman even said that, or was always on the defendant about something. Your words?
Yes.
And a couple of days before Mr. Brackman was killed, Avery Becker vandalized Mr. Brackman's property, his Porsche. Is that correct?
She did, but Avery seemed very remorseful about what happened that night.
That wasn't my question. She did it, yes or no?
Objection, Your Honor, badgering. My witness answered to the question with a yes at the beginning of his answer.
Your Honor, yes, Your Honor. Again, this is proper cross-examination into the bias and credibility of the witness. I was simply redirecting the witness back to my question to answer it in a yes or no fashion. I'm not badgering the witness, simply asking them to follow along with my questioning.
All right. Any reply?
Your Honor, I believe that if my witness gives the answer of yes or no at the beginning of his answer, and then they are asking not open-ended questions, but answers that some or I believe that my witness should be able to elaborate on some answers if needed.
All right. I'll overrule the objection. Go ahead.
So once again, Mr. Perkins, that's a yes to my question. She did do it.
She did, yes.
And after being kicked off the team, like we've already established, she tried to get back on.
Yes.
But the victim never changed his mind, did he?
No.
And the next day, and then afterwards, Avery Becker tried to go and meet Mr. Brackman. Isn't that also right?
That's correct. She tried to meet with him and apologize and even offer to pay or repaint his Porsche.
That's right. But again, he never changed his mind, did he?
He did not.
Now, finally, I'd like to talk about the phone that you mentioned a lot during direct examination. To be clear, nowhere in your affidavit do you mention seeing Alex touch Avery's phone, do you?
No, but the phone was still on the table where we left Alex sitting down at the fry shack.
So that's a yes to my question. Never in your affidavit do you mention that Alex touched Avery's phone.
No, I do not mention that.
And you knew you had an obligation to update your affidavit with any new or relevant information prior to trial today, yes or no?
Yes.
And you also, and nowhere in your affidavit do you mention Alex needing to use the phone, do you?
No, I do not.
And again, you knew you had an obligation to put in any new or relevant information regarding today's trial, and you didn't, did you?
I did not.
You also called Avery Becker's phone a third kidney. Am I remembering that correctly?
Yes, it was like attached to her hip. She never let go.
But just to be clear, Avery wasn't very worried about her phone being stolen or missing, now was she?
Well, we didn't realize it was missing until the next day.
That's right. Avery somehow didn't notice her phone, her third kidney, was missing for over 12 hours. Isn't that right?
I guess that's right.
And once you met up with Avery Becker, you were the one suggesting places to go look for it. Isn't that true?
That's correct.
And you were also the one who suggested that the phone was missing in the first place. Isn't that also right?
That's also correct.
Thank you, Your Honor. I have no further questions.
Very well. Redirect.
Yes, very briefly, and I want to ask for a brief time check before I start.
The defense has 8 minutes and 10 seconds remaining.
Thank you. Mr. Perkins, did you make Exhibit 15?
No, I did not.
And if you would you have marked out the fry shack in the mall?
Yes, I would have. Those are important places where we looked for her phone.
And moving on, you said that you thought Alex, or that Avery had texted Alex, correct?
Yes, I did say that.
But there's no way to know because you are not Avery?
That is correct, yes.
No further questions at this time, Your Honor, and barring no recross, I ask that my witness is able to step down from the stand.
That'll be fine. Let's have our next witness.
Yes, Your Honor. The defense would like to call Avery Becker to the stand.
All right.
Good afternoon. Please state and spell your last name for the record.
The witness is muted, so I think we need to push that button.
Avery Becker, Becker.
And you went to Colorado High School last year, is that right?
I did as a senior.
What activities did you do at the high school?
I was part of CHS's mock trial team for 4 years.
And on that mock trial team, Mackenzie Brockman was your coach, right?
Yes, he was. I'm sorry. I can't believe he's gone now.
I know this is really hard for you to talk about, but could you describe your relationship with Mackenzie Brockman?
Yes, Coach Brackman and I, we didn't really get along, and didn't like my work ethic that much.
What happened because of the conflicts between your coach?
A month before regionals competition, he demoted me to a B team.
And what happened because of that demotion?
I tried talking to Coach Brackman, but that didn't work out. So Taylor had this idea to quit since he thought a team couldn't win without me. He didn't really like mock trial in the first place. So after that, I was put back on A team.
Did you have any other major conflicts with your coach after that?
After our regional competition during practice on Tuesday night, Coach Brackman started getting at me and said that my work wasn't up to his liking. And in that moment, I got angry and irritated, grabbed a marker and wrote "Worst Attorney Award" across the hood of his car. It was the dumbest decision of my life.
And I know it's really hard to talk about these decisions. What were your feelings afterwards?
After that, I went home and talked to my mom. And after I calmed down, I realized I made a terrible mistake. And it made sense why Coach kicked me off the team for it.
And you obviously seemed upset. What did you say to your mother?
I told her that if it was the last thing, I would get back at Coach Brackman if it was the last thing I did.
Did you mean what you said?
I mean, in that moment, I thought I was right, and I meant it, but after calming down, I realized I was wrong, and I made a terrible mistake to write on his call like that.
And after you realized you were wrong, what did you do?
The next day, I went to Coach Brackman's office to try and apologize to him, but he didn't want to see me. So I even offered to work the whole summer to pay off for the damages I did, but I never got the chance to apologize to him and never will now.
Now, let's move on to March 6, 2020, the day that your coach passed away. Where were you on March 6th?
I was with my best friend Taylor all day. We skipped school to go to the fire shack in the mall to look for my phone that I lost the day before.
When did you last see your cell phone?
I last saw my phone March 5th, the day before Coach Brackman's death.
And where did you last see your cell phone?
At the fire shack where the whole mock trial team was. Even Alex was there.
How did you try to find your cell phone?
Taylor tried texting and calling my phone, but we were never able to find it.
Now, I'd like to move on to the investigation that was led into you. Were you present? You were present here when Miss Kyle Cusack testified about alternate suspects, right?
I wasn't. I'm shocked to hear that there were 1, 2, but 3 suspects, and why I was the only one investigated and the other 2 suspects weren't.
Are you familiar with any?
Objection, Your Honor. May I be heard?
Yes, please.
This is improper lay witness testimony pursuant to Rule 701. As Ms. Becker does not have the expertise to testify as to the quality of the investigation, and also does not have the personal knowledge pursuant to Rule 602 of who was investigated in this case.
Response.
Your Honor, pursuant to 701A, this is the witness's rationally based perception, as it is based on her testimony that she heard from Kyle Cusack today in court, personally listening to the testimony today, as none of these witnesses were sequestered as per stipulation by the prosecution.
Reply, if any.
Yes, Your Honor. While Ms. Kuzak did testify earlier as to the investigation, it is still improper lay witness testimony for Ms. Becker to testify as to this investigation because she does not have the expertise necessary to testify as to the quality of this investigation, and doing so is substantially more prejudicial than probative pursuant to Rule 403, as her testimony has no probative value and only seeks to prejudice the jury against the prosecution.
Well, in a real trial, I might sustain the objection for purposes of the competition. I'm going to overrule it, so you can go ahead.
Ms. Becker, are you familiar with the other two suspects Ms. Kuzak mentioned?
Yes, I am. I went to school with both Blair Rowlands and Alex Cifuentes.
And who is Blair Rowlands?
Blair is a fellow classmate of mine. I'm surprised they weren't investigated.
Why do you say that?
Blair is similar in size to me, so we could easily been confused. And also, Blair was Alex's friend.
And you mentioned Alex.
Objection, Your Honor. May I be heard?
Yes, go ahead.
This is speculation pursuant to Rule 701, as well as since Ms. Becker cannot rationally base upon her perceptions and observations who Blair Rowlands was friends with. Furthermore, Ms. Becker has a lack of personal knowledge as to Ms. Rollins' personal life.
Your Honor, as you've heard from testimony from numerous witnesses, that Avery Becker, along with Blair Rowlands and Alex Cifuentes, all went to school together for 3 to 4 years. And based on those 3 to 4 years, I'm pretty sure that my client would be able to identify who was friends, what the cliques were at Colorado High School mock trial, as well as the school itself.
Reply, if any.
Yes, Your Honor. Simply the fact that Ms. Becker went to school with Blair Rowlands and Alex Cifuentes is not sufficient knowledge to show that Ms. Becker knows who Blair Rollins' friends were, especially as I anticipate that if asked, the defendant would state that she did not know Blair Rowlands that well.
Very well, the objection is noted and overruled. Go ahead.
Now, you mentioned Alex Cifuentes. Who is Alex Cifuentes?
Alex is a fellow mock trial teammate of mine, but we don't really get along. I'm surprised to hear that she called me her friend today. Even said that she was jealous of me.
Now, did you listen to Ms. Cifuentes' testimony today?
I was present for it.
And I'd like you to refer to Exhibit 14 for me, please. Do you recognize the exhibit at all?
I'm not really sure what these are. I've never seen them before.
Did you ever text Alex Cifuentes?
No, I've never texted Alex.
Now, I just got a few more questions for you. Did you break into Mackenzie Brockman's residence?
No, I don't even know where Coach Brackman lives.
Did you kill Mackenzie Brockman?
No, I would never do such a thing to anyone, and I would never hurt Coach Brackman.
Thank you. No further questions at this time, Your Honor.
Very well. Cross-examination.
Yes, Your Honor. Before I begin, can Your Honor see and hear me all right?
Yes, thank you.
Ms. Becker, first I'd like to talk about something you said on direct examination. You expressed regret for your relationship with Mr. Brackman. Did I understand that correctly?
Yes, I mean, we might have not been on the best terms, but I miss Coach Brackman.
However, didn't you also say that he had a massive ego?
I did.
And you even went so far to call him a joke, didn't you?
I did back when he was still with us.
Wait a second, you wrote those in your affidavit, which was after Mr. Brackman was murdered, isn't that right?
I did, and like I said, we didn't really get along. So
Now let's talk about your motive. Like you said, you and Mr. Brackman didn't get along, and you argued at almost every practice, didn't you?
we did. He didn't like my work and my work ethic.
Well, you argued at every practice up until he kicked you off the mock trial team 3 days before he was murdered. Isn't that right?
Yes.
And you were kicked off the team at that time because you vandalized his car with a permanent marker. Isn't that right?
Yeah, it was a stupid mistake, and I regret it. And I was wrong for doing so.
However, you did it, didn't you?
Fortunately.
Getting kicked off the team made you angry, didn't it?
I mean, it was the last year of me doing mock trial, and it was right before the state competition.
Is that a yes or a no to my question, Ms. Becker?
Yes.
Your Honor, asked and answered.
I'll overrule. Go ahead.
So is that a yes or a no to my question? Getting kicked off the team made you angry?
Yes, it did. And I thought I was right at the time, but I wasn't.
So angry, in fact, that as you said on direct examination, you told your mother that you would get back at Brackman if it was the last thing you did. Isn't that right?
Yes, I did tell my mom that, but once I calmed down, I realized I was wrong, and I would never do anything to hurt Coach
Objection, Your Honor.
Brackman.
May I be heard? I object non-responsive. I asked a clearly framed yes or no question, specifically that if Ms. Becker said that she would get back at Brackman if it was the last thing she did. At this time, I would like to remind the court that this is a timed competition. If the witness feels that further explanation is necessary, she may do so during her own time upon redirect.
Response?
Your Honor, on cross-examination, any question posed to the witness, she's allowed to elaborate on, even if it's being phrased in a yes or no answer. Regardless of the fact that this is timed, she's allowed by her right to testify to elaborate on why she did something, why she didn't do something, or any of that manner posed by opposing counsel's questions.
Any reply?
Yes, Your Honor. Pursuant to the rules of upon cross-examination, as this is a timed competition, the witness is directed to answer with a yes or no, especially since I framed my question in a yes or no manner. If the witness feels that further explanation is necessary, again, she may do so upon her own time on redirect.
Your Honor, if I may.
Go ahead.
Your Honor, nowhere in the rules of the competition, as opposing counsel is claiming to cite, does it say that a witness is directed to say yes or no. She's allowed to elaborate on cross-examination as well as direct examination and redirect examination, as she's allowed to elaborate on her answer, especially when the answer is calling for an elaboration.
All right. The objection is noted, and in this case, sustained. Go ahead.
So, Ms. Becker, is that a yes or a no to my question? You told your mother that night that you would get back at Brackman if it was the last thing you did.
Yes.
Now, I'd like to talk about the prosecution's investigation. You saw the Ring doorbell videos earlier today, correct?
I did.
And we can agree that you match the general height and build of the person in those videos?
Yes, but that wasn't me.
But that's a yes to my question. You matched the general height and build?
Objection, Your Honor, asked and answered.
Your Honor, I was simply seeking to clarify for the jury whether the witness was answering yes or no to my question as she continued to explain her answer.
Very well. I'll overrule the objection in this instance. Go ahead.
So that's a yes to my question. We can agree that you match the general height and build of the person in the Ring videos?
Yes, like I said in my previous answer.
We can also agree that you skipped school on March 6th of 2020, isn't that right?
Yes, as I was looking for my missing phone with Taylor all day.
We also agree that Ms. Perkins is the only one testifying that you were looking for your lost phone that day, isn't that right?
Yes.
Ms. Perkins is your best friend, isn't he?
Yes, like I said, in my testimony, he is.
Now, let's talk about the map. May my trial technician publish Exhibit 16 to the jury, which has previously been admitted into evidence?
Yes, certainly.
Ms. Becker, if we would look at the top, can we agree that your house is in the red shaded region? Isn't that right?
Yes, it appears so.
Meaning that your phone was in that general area at that time, isn't it?
Objection, Your Honor, speculation.
Response?
Yes, Your Honor, this is not speculation pursuant to Rule 701. As opposing counsel previously stated, Ms. Becker has been present for the testimony of all witnesses today, including that of Detective Jordan Markowitz. As Jordan Markowitz testified as to what the red shaded areas mean in the CDR data, Ms. Becker can testify as to whether or not her phone was likely in that area.
Reply.
Your Honor, as a lay witness, this witness cannot be allowed to testify specifically about speculating where her cell phone was, especially since she doesn't have the knowledge, training, or expertise to specifically talk about and be trained in cell call detail records, and especially to know about her own cell phone when she does not have those records provided.
Objection is noted. Oh, yeah, go ahead.
Your Honor, I would like to remind the court that it has previously been ruled that Ms. Becker can testify as to information previously testified by experts without needing expertise. In this instance, I'm asking her to verify the information from Detective Markowitz's testimony, which is not speculation pursuant to Rule 701.
Understood. In another context, I might sustain the objection, but in this context, I overrule it. You may proceed.
So, Ms. Becker, as you heard Detective Markowitz say earlier, this means that your phone was likely in the same area as your house, isn't that right?
Yes, my phone was, but I didn't have my phone on March 6th, the day of Mr. Bracken's death.
Is that a yes to my question, Ms. Becker?
Yes.
Thank you. The exhibit is no longer needed. Finally, I'd like to talk about the messages. You did attempt to get back on the mock trial team, isn't that right?
I did. I tried talking to Coach.
May my trial technician publish Exhibit 14 to the jury, which has previously been admitted into evidence?
Yes.
Ms. Becker, that is your name in the contact information at the top of the exhibit, isn't that right?
It looks like it.
And in these texts, the person labeled as Avery Becker tries to get back on the mock trial team, don't they?
Yes, that's what they say.
Thank you, Your Honor. I have no further questions at this time.
Very well. Redirect.
Yes, Your Honor, but before I do, can I inquire the court on a time check?
The defense has 42 seconds remaining.
Thank you. Ms. Becker, do you know where your phone was on March 6th?
I don't know. I lost my phone and I tried looking for it, but I don't know where it is.
And you also got to see Exhibit 14 again. Did you send any of those text messages?
No, I've never did. I don't even know what they are.
And lastly, Ms. Becker, would you have done anything to harm Mr. Brockman?
No, we might have not gotten along, but I would never do anything to hurt Coach Brackman.
Thank you, Your Honor. I have no further questions. And barring any recross by opposing counsel, I ask that my witness be allowed to step down from the stand.
Your Honor, if I may conduct a brief recross.
Briefly, yes, go ahead.
Now, Ms. Becker, I know you said that you lost your phone on March 5th, but the only one testifying to that other than yourself is Ms. Perkins, isn't that right?
Objection, Your Honor, outside the scope.
Response?
Yes, Your Honor. Upon redirect, opposing counsel asked if Ms. Becker had lost her phone on March 5th of 2020, and as such has opened the door into questions regarding the credibility of that statement.
Your Honor, if I may.
Go ahead.
Your Honor, nowhere in this redirect examination did Avery Becker or myself mention Taylor Perkins or communicating about Taylor Perkins, and that has been outside of the scope of my redirect examination and is outside the scope of recross examination by opposing counsel.
All right. Objection is noted and in this context overruled. Go ahead.
Ms. Perkins is the only one here today other than yourself testifying that you lost your phone on March 5th of 2020, yes or no?
Yes.
And you also mentioned, and as you mentioned earlier, Ms. Perkins is your best friend, isn't she? Or isn't?
Objection, Your Honor, outside the scope.
May I respond?
Yes, go ahead.
Again, Your Honor, this goes into the credibility of Ms. Becker's statement that she was not in possession of her phone on March 5th of 2020. As Ms. Perkins being the only one to corroborate this testimony, and Mr. Perkins's testimony is biased as he was the best friend of Avery Becker.
I'll overrule the objection. You can go ahead.
As you stated before, Ms. Becker, Mr. Perkins is your best friend, isn't he?
Yes, Taylor is my best friend.
Thank you, Your Honor. I have no further questions at this time.
Very well. Witness may step down. Are the parties ready for closing argument?
Yes, Your Honor. At this time, the defense rests its case in chief.
All right, thank you. I guess I got a little ahead of you there. So if you're ready for closing, go ahead.
Yes, Your Honor. May I have a moment to rearrange my virtual courtroom?
Yes, indeed.
My apologies, Your Honor. My camera is still loading.
It's all right.
Now, Your Honor, before I begin, I have 3 requests. First, as a reminder, I ask that all time remaining at the end of my closing argument be reserved for rebuttal.
That's granted.
My second request is that the jury instructions be constructively read into the record.
Granted.
And my third request, Your Honor, is that during the course of my closing argument, my trial technician be allowed to display pieces of evidence that I'll be discussing that we've already admitted into evidence and that we've already sought to publish. In particular, I'll be discussing Exhibit 14 and Exhibit 16, and I ask permission from my trial technician to display those exhibits during the course of my closing argument. I also ask that jury instructions 7, 8, and 9 also be displayed, as I'll be discussing those as well.
That will be fine.
May it please the court. You can hide your face behind a mask, but you cannot hide the truth. And the truth is in the map, the messages, and the motive. The prosecution and defense agree on a lot today. We all agree that a burglary happened. We all agree that during said burglary, Mackenzie Brackman was killed. And we all agree that a person wearing a mask and matching the size and build of the defendant is the one who committed these crimes. The only dispute here today is over who wore that mask. But members of the jury, that mask cannot hide the truth, because the truth is in the map, the truth is in the messages, and the truth is in the motive. The map. Detective Markowitz showed you with Exhibit 16 the route taken from Avery Becker's house to the home of the victim. The detective explained how cell towers tracked Avery Becker along this route, placing her at the scene of the crime at the time of the burglary and murder. The messages. You saw the text messages sent from Avery Becker to Alex Cifuentes. Texts that expose the bitter truth of Avery Becker's intent. Let's hear those texts again. Well, if he's still upset about what I did to his car, then he's going to be really upset when he sees what I do to his house. I'm going to wait till he's at work, then break in and trash it. That'll show him. And that's exactly what Avery Becker did. She waited until she thought Mr. Brackman was at work, broke in with the intent to do damage, and then stabbed Mr. Brackman with the very knife he used to defend himself. The motive. As we heard time and time again today, Avery Becker and Mr. Brackman have had a history of petty fights and low blows, escalating to the vandalization of his 1986 Porsche. Failed attempt after failed attempt to get herself back on the team made Avery Becker angrier than she'd ever been before. So she put on the one thing she thought would hide herself, a mask, and made a promise that she would get back at Brackman if it's the last thing she did. Now, as the prosecution, we've charged the defendant with 2 crimes, murder in the first degree and second-degree burglary. But in order to understand murder in the first degree, it's helpful to talk about second-degree burglary. So let's talk about it. Jury instruction 8, which is displayed for you now, spells out the crime of second-degree burglary. And jury instruction 9 spells out the crime of criminal mischief, the very crime the defendant intended to commit when she entered Mackenzie Brackman's house. So when you put it all together, we've proven the defendant is guilty of second-degree burglary because she entered Mackenzie Brackman's house without permission and with the intent to cause damage to his property. So now let's talk about murder. Jury instruction 7 indicates the different elements of murder in the first degree. It says that Avery Becker committed this crime if Mackenzie Brackman died as a result of the home invasion on March 6th. Members of the jury, the defense's own theory is that Mackenzie Brackman died on March 6th. So the only question left for you is who wore that mask? We've answered that question for you. You know it was Avery Becker behind that mask because we showed you the map. We showed you the messages, and we showed you the motive. We, the prosecution, have met our burden of proof. Find the defendant, Avery Becker, guilty. Thank you.
Thank you, counsel.
Your Honor, before I begin, I need to raise an issue within the bar, as the closing statement made by the opposing counsel violates rule of the competition 4.7 with enlargements on the evidence which is prohibited under rule 4.7 of the competition. Would you like my co-counsel to pull up the rule 4.7 for you, Your Honor?
Yes, please.
And Your Honor, I'm mainly referencing enlargements of the case materials are not prohibited. And this is different from 7.4 with zooming in on that. We have no objection to zooming in. However, these case materials were specifically crafted for the purposes of enlarging certain amounts of text, as you just saw in their closing argument. And we ask that, that this be reassessed by the scoring panel.
I'm not sure I fully understand your objection, counsel. Can you explain?
Yes, Your Honor, pursuant to 4.7, the enlargements of the case materials are not prohibited, and how the opposing counsel has zoomed in on specific areas of the evidence, mainly the text messages, as well as highlighting boxes, would be fine under demonstrative evidence purposes by witnesses. However, these were not taken in proposition with demonstrative evidence, and is directly violating Rule 4.7 of the competition.
So if I understand you, you're saying that these enlargements are permitted
That is
during
correct,
witness
Your Honor.
testimony, but not during closing argument.
Your Honor, the enlargements are not permitted at all. However, 7.4 does permit the zooming in on using these zoom features, such as in this example. However, the opposing counsel and the opposing party, the prosecution, has created specific presentations by enlarging them in red boxes and highlighting the enlargement from exhibits 14, as well as the jury instructions, which again is a direct violation of Rule 4.7 of the competition.
Response?
Your Honor, during a pre-trial today, my co-counsel asked permission to enlarge pieces of evidence during the testimony in today's case and during the case in general. Again, as opposing counsel just stated, enlargements are permitted in today's case. And what we did during closing argument was enlarging pieces of evidence to direct the jury's attention to those lines. That's not inadmissible pursuant to Rule 4.7, as opposing counsel just stated.
Your Honor, if I may.
Go ahead.
That the opposing counsel is directly misquoting of what was covered in the preliminary matters. Is their opposing counsel, I believe it was Miss Hannah Feely, testified, well, not testified, but stated that they wanted to zoom in on these, not enlarge. And zooming in would be fine, but the manner that they've conducted this in is, as you can read on it, enlargements of the case materials are not permitted under 4.7, and it's a direct violation of the mock trial rules of competition.
Your Honor, may I respond?
Yes, go ahead.
Further, Your Honor, I understand opposing counsel keeps saying that enlargements and zooming in are not the same thing, but enlarging something is zooming in on that topic. And furthermore, in Rule 4.7, it says, teams may use and refer only to material provided in the case. No illustrative aids or any material not provided. Exhibit 14 and Exhibit 16 are provided in the case, and we testified to them numerous times throughout today's case. This is allowed under Rule 4.7 in the rules of competition.
I might have a moment to read the rule. Well, I'm a little confused, counsel. It says that enlargements are not permitted. And as I recall, pre-trial, we all agreed that there could be zooming in. I don't remember if we talked about using the word enlargements.
Your Honor, I would agree with you on that statement. Pursuant to 7.4, zooming in is part of the Zoom features which are permitted under 7.4. However, these case materials, as opposing counsel has said, are from the case materials, but the enlargements that they have used in their presentation are not present. And to write on or mark up these exhibits would have to be done under witness testimony with demonstrative aids, as well as entering those demonstratives and publishing them to the jury to be used in this format. And again, pursuant to 4.7, enlargements of these case materials are not provided, especially since these enlargements are not from the case materials themselves in the same manner, as these exhibits have already been marked up.
All right, one more response, counsel.
Yes, Your Honor. If the trial technician would scroll back down to Rule 7.4 again. A little bit farther, please. One more. It says teams may use technology to mark exhibits electronically. Any marked electronic exhibits may only be used in the stated exhibits that are presented in the case problem. Your Honor, those are the exact words of the ruling, and that's exactly what we did in our closing argument. We marked exhibits that were already presented in the case file, that were already admitted, we already sought to publish, and then presented that to the jury. I don't understand opposing counsel's argument as what we did is allowed in the rules under 7.4 and 4.7. Again, in pretrial, you allowed for us to zoom in and mark exhibits. And so what we did in closing argument is under direct ruling in your pretrial and in the rules of competition.
Your Honor, before you rule on that, can I ask that the remaining part of 4.7.4 be read, as it states that it's only these Zoom tools that may be used in marking those exhibits?
Well, okay, so I did see that. This is what we call in the law a nice question, which means it's a difficult question. In my view, the rules are not entirely clear on this point. And that being the case, and I understand this is an important objection because it goes to following the rules of the competition, and that's a big deal. And scoring judges are likely to consider it a lot. So I am going to rule that while it is a closed question, that the objection is overruled. I will not penalize, and I suggest that the scoring judges not penalize counsel for that use of exhibits in closing. As I say, the objection is interesting, and the rules, in my opinion, aren't sufficient to deal with this problem. But given that, I think I have to rule in favor of the defense on this one, so that's what I do. Carry on.
Yes, Your Honor. And for the closing argument by the defense, are you ready, Your Honor?
Yes, go ahead.
Your Honor, opposing counsel and members of the jury, this case is as easy as 1, 2, 3. Today, you saw the tragedy. First, the tragedy of Mackenzie Brockman's death at his residence. However, before I begin with any of the evidentiary things in my closing argument, I'd like you to refer to the jury instructions referenced by opposing counsel. The one element that they have failed to prove is where this murder and burglary occurred. They have not proved an exact location, whether that be in the state of Colorado or even in the United States entirely, let alone Denver County. And based on that alone, ladies and gentlemen of the jury, you are entitled to rule not guilty because they have failed to prove their burden on one of the aspects of the charges. And by the jury instructions, you must find Avery Becker guilty of beyond a reasonable doubt on all aspects. And because they have failed to prove one aspect, the address and whether this crime was committed in Colorado, you must rule not guilty. However, I'm going to continue to talk about the evidentiary notice of a rushed prosecution and a rushed police investigation. Firstly, let's go to how this investigation was tainted. First, you heard from Alex Fuentes, who testified about providing an incomplete text conversation, supposedly between Avery Becker and Alex Fuentes. Not only can we not authenticate whether this conversation was with Avery Becker, this conversation is not complete. Then you saw from Jordan Markowitz the inconsistencies from the photographic evidence. Not only that the body had been moved, the crime scene tainted, but also the murder weapon in general. The chef's knife from Exhibit 5 and 6 was different. Whether it might be a mirror image or not, they are not the exact same knife. And ladies and gentlemen of the jury, that is doubt. This investigation was tainted. And then as you heard from Kyle Cusack, Avery Becker was 3, targeted for a lack of evidence and rushed investigation, relying heavily on a general height and build. You heard from Avery Becker testify today that she's not the only person with a general height and build similar to hers at her school. That's where we look at Blair Rollins, the son of a client of Mackenzie Brockman, who would have a stronger motive, according to the map, according to the messages, and according to the motive. Ladies and gentlemen of the jury, I'm going to unmask the prosecution's Rust investigation to show you the truth that Avery Becker is innocent. You heard from Professor Blake Van Owen, who testified to the fact that this investigation was rushed, that there was missing evidence, not only from photos, but also from the scuff marks that the prosecution so heavily relied upon in a tainted investigation. You saw that these scuff marks could be made 1, 2, 3, or many more weeks earlier. We don't have definitive proof that there was a scuffle. Then you heard from Taylor Perkins and Avery Becker that on March 6th, 2020, the day of Mackenzie Brockman's death, they were off at the Fry Shack and they were off at the mall to look for Avery Becker's cell phone that they had lost the day before. How can we rely on the call detail record map if Avery Becker was not with her cell phone? The call detail record map that the prosecution has so heavily relied upon is not definitive and frankly tainted. We also look at Avery Becker to look at her remorse that she had for what she did to Mackenzie Brockman's Porsche beforehand. However, just because of the scuffles that she'd had with him before does not mean that she would attack and murder or burglarize Mackenzie Brockman's residence. Because as she stated before, she did not mean what she said to her mother, and those text messages did not come from Avery Becker. Ladies and gentlemen of the jury, I'd like to remind you of jury instruction number 2, that Avery Becker is presumed innocent and is presumed innocent until and only until you find Avery Becker guilty beyond a reasonable doubt. And ladies and gentlemen of the jury, the prosecution has not proven that. They have failed to not only prove the address that it was committed in Colorado, but have also failed to prove that it was Avery Becker. Unmasking this investigation, you have seen that it is not Avery Becker, but someone else. And that person is still out there at large. Ladies and gentlemen of the jury, this case is as easy as 1, 2, 3. Thank you.
Thank you, counsel. I believe at this point, the trial has effectively concluded and the scorekeepers should be about their business.
I don't mean to interrupt, but can I do my rebuttal?
Oh, I'm sorry. I completely forgot about your reserved time.
No worries, Your Honor.
And carry on.
Can you see and hear me all right?
Yes, I can.
And before I begin, may I inquire as to how much time I have remaining?
You have 1 minute and 9 seconds remaining.
Opposing counsel just framed this investigation and this case as simple as 1, 2, 3. We wholeheartedly agree. 1, the map. 2, the messages. And 3, the motive. But where we disagree is in the tragedy, the tainted, and the targeted. The only tragedy in today's case is that Avery Becker sat in front of you today, knowing full well of her actions, and lied to you about her innocence. The only tainted investigation in today's case is Blake Van Owens, who spent a mere 31 hours on this case. And the only targeted is poor Mackenzie Brackman, who died because of Avery Becker's actions. Now, remember, reasonable doubt is not vague, speculative, or imaginary, but the defense gave you a vague story, and they asked you to speculate about imaginary evidence. But we showed you the simple truth as 1, 2, 3. We showed you the truth in the map, the messages, and the motive. Find Avery Becker guilty. Thank you.
Thank you, counsel. Am I right in thinking it's time to do scoring, or have I got ahead again? Well, alrighty then. So if the scoring judges would carry on and submit your scoring sheets, we'll do what we need to do after that.
Yep, and you guys can all wait to get confirmation from Ashley when they receive your scoring sheet, so you can go ahead with remarks when you're done with your scoring sheets. And I'll let you know when she receives them.
Okay, thanks.
Thanks.
I would just like to say on behalf of both teams that we're both very thankful for you judging our competition, and all of the scoring judges for staying here and witnessing all of what we do. It makes the competition a lot better.
And thank you for providing a platform for us in a time where we didn't even know if we'd get to compete this season, and allowing us to even go as far as to make it to state competition. Thank you all so much for judging and for taking time out of your weekends and to sit and be here for us.
Thank you for saying so. Happy to be here.
I just want to say, everyone breathe. You did a great job. And also, now you get to see what our life is like right now in courts, because a lot of our court appearances are done this way by Zoom, and it is not easy. It is so much better to be in the courtroom and to be able to see the witness up on the stand. So great job to everyone.
Okay, it looks like Ashley received all of your guys' scorecards.
Outstanding. Which of our scoring judges would like to make some remarks first? Holly, go ahead.
I'll start, I guess. I don't know if I should go through all of them or just some, but I like on Hannah for your opening, the good use of the 3 for the roadmap, and the fact that the roadmap was revisited many times. And Jaden, you had the same thing, although I think I had a better time. You know, I love roadmaps, but I remembered the plaintiff's roadmap a little better than the defense. In fact, I wrote down tragedy tainted, and I didn't write down what the third one was, so I somehow missed that. So that was good. I think you were both well-spoken on your openings and did a great job. Let's see. Hannah with Alex Fuentes, the hand gestures were very natural and relaxed, and that was really nice. Maybe a little more light in your room because you like to move, and I like that you moved, but we got kind of a little bit in the darkness. So if there's any way, you know, without spending money to lighten up the room a bit for that little wander over there, that would probably be good. And then for the witness, for Grace, I like that you looked closely at the text like you were actually reading it and trying to like, remember. That was good, and good inflection for your testimony. The cross, see, what do I have here? I can't even read my own notes. Oh, excellent job. Good job impeaching the witness with the affidavit and the screenshots. And object when she said something about, oh, I'm here because Avery killed my coach or whatever. Don't let that get out. I would object to that. But that's, for next round, that's something I would look at. Anna, you have very smooth questioning for the Detective Markowitz. The witness, I love the nice facial and hand gestures, good inflection, reading a little bit, but you were very good on cross-examination. Will, you did a great job with moving going over the actual evidence. I thought it was very powerful to poke holes in the case. Good job with the Rollins house on the map and pinging the evidence. Let's see. Anika, you did a good job. I would just say maybe, or is it Annika? Did I say that wrong? I'm sorry if I botched your name, but anyway, slow down a little bit. You do a great job as well. I tend to talk too fast, and so I totally get that, but you did great. Kyle Pilar, good job of noting not everything was in the documents, and the 5-step analysis I thought was powerful. Let's see. I'm going to say we don't have that much time, so I'm going to close it down, but I felt like the best cross-examination was Anna. I thought she did a great job on the defense witness number 1. So you guys, great job. Glad you're here. Hope to see you someday in the courthouses.
Julia, are you a scoring judge?
Yes, I am. And I'm happy to tell you guys how well you did. I don't have specific notes on you individually, but I just want to tell you that you all did an excellent job. You were very prepared. I scored the earlier rounds several weeks ago, and I must admit that I was very impressed by your presentations today. Specifically, I want to tell you that you did an excellent job in sticking to your themes throughout the case. And I think that the fact that the prosecution named their 3 elements instead of numbering them and just, talking about 1, 2, 3, I thought that actually just was easier to remember. So that just would be a note for the defense going forward. Also, I thought on cross-examination, some of the most powerful cross-examinations were the ones where you could get the expert to agree with what you were saying. It seemed like, the witnesses were squarely on you. They wanted to elaborate. They didn't want to answer yes or no. I thought that everyone did a good job of trying to rein the witnesses in. And that oftentimes results in going back and forth with the objections, but that's how it is. And I thought that you did a very good job of, remaining confident, arguing your point. When the witness does evade your answer, you can use those tools. You can ask them to say yes or no, or you can ask them to agree with you on certain points. Or if you're the counsel for that witness, make notes so that on redirect, you can go back to that point so that it's not lost in argument. You can just ask the expert, where they're going with it, and then you can just ask them to clarify. So then they can explain themselves however they want to explain themselves, and you won't get an objection. Let's see. The one thing that I would say, I just thought you were all very well prepared in sticking to the themes. One thing that is important to do when you are examining your witnesses is make sure that you hear what they say. I'm sure by this time you guys have all practiced all your examination questions so much, and you've done it a couple of times, but don't get into the trap of just reading from your script. Make sure that you listen to the response that the witness gives you, because it may be different. And then your follow-up question, especially on cross-examination, won't make sense if you didn't respond to what the witness says. And I know that happened a couple of times, and that happens all the time, and it's not a negative thing, but that's something that you can learn from, because you can say, oh, right, I know I have my script, but I need to listen. And a lot of trial work is active participation. And a lot of it is just thinking of on your feet. And all of you did an excellent job with that. And that's just something to highlight. And then the only other thing that I will mention is that, especially in this case, I think it's important to talk about the distinction of, between murdering someone and a prank like drawing on a car, right? And I know that that did come out a little bit in the defense witness's testimony about how he couldn't imagine his friend would do that. And then I think that that's a point that can be taken further down the line if you're the defense, because you can, instead of pointing fingers at other potential witnesses, just really hammer on the fact that it isn't reasonable, even if Avery intended to break into the house and do some looting or something. If her teacher came at her with a knife, would she really have fought him? What would her reaction really have been? Would she have said, oh, I'm so sorry, and turned around and run away? That's one of those points where you kind of want to think about it in terms of human reactions and see how you can humanize the story so that the jury can really understand what your argument is and figure out if it really makes sense, your story. But I thought you guys did an excellent job, and I really enjoy scoring these.
David, would you like to go next?
Sure. First of all, let me qualify myself here. I am a legal IT specialist for 2 law offices here in Colorado. I've been doing that for 6 years, and I've attended NEDA at least 7 years because I provide IT support for them as well. NEDA is the National Institute of Trial Advocacy, where real lawyers go through all the training that you're going through about how to do openings, closings, cross, and what have you. So I think, first of all, the opening with the rule of the 3, I think both teams had that nailed. I've heard many openings for the same case in NEDA. Sometimes they say less is more, so 1, 2, 3, that works. But I do like, having names a lot better. So I think you all carried the theme through entirely through your cases, even into closing, which I thought was really good. I'll tell you, I really enjoy the witnesses. The experts have to come off as experts, like they know what they're talking about. And I think both teams did really well on that. And people like the friends. Jeff, I don't know if that's your name or if Taylor is your name, but I really loved your character. You had a lot of emotion to your character. And I perked up, when I heard you and listened, so I think you did an excellent job on your acting. So good job on that. Anna, I really want to give special kudos to you because, again, through all the cases that I've attended as an IT specialist and through NEDA, you are the first person I ever heard break down the hours of their work that the expert actually put in, going backwards through the cost and the hourly work. That was a really great point, Anna. It's the first time I've heard it, so special kudos to you for bringing that up. Brendan, I really have to give a special shout out to you. First of all, you had technical difficulties, and as an IT spec, I've been there, done that, and you kept your cool, and that's the important thing. But you really kept your cool in the closing there with your objection. My managing attorney has a sign outside of his office that says collegial, professional, and respectful. And you were very passionate about your objection. And another thing that my managing attorney will ask during an attorney interview for a job, he'll ask you, when is the right time to yell at a judge? Judge, do you have an answer to that? Yeah.
Well, I have an answer in my private practice, and I have an answer as a fake judge. In my private practice, you can always yell at a judge, especially practicing for 40 years, and you can get away with it because it's a younger judge. But as a judge, it would drive me nuts. So the answer David is looking for is never.
But Brendan, you kept your cool, and when your technology wasn't up and running right away, and during your objection, you were collegial, professional, and respectful the entire time. So special kudos to you on that.
Dan, do you have some remarks?
Hello, everyone. I think I might be the only law enforcement officer here on this panel. I've been in law enforcement for 19 years. I'm an investigator. I work in human trafficking and crimes against children. And I'm actually moving over to a special victims unit soon for domestic violence, sexual assault, and human trafficking. I've sat on trials as advisory witness, and I work with attorneys every day at this point. I'm no lawyer, no expert at the law, and I would say every one of you know probably more about trial strategy and all that stuff than I'll ever know. But just to start real quick with the witnesses, everyone did a great job, but I was really impressed. I'm looking at Blake. I think I have the name right. Really liked it a lot. Just your demeanor and the way you testified, and just it was pretty impressive the way you came across, and Pilar as well. Like I said, I mean, I don't have a lot of time because it looks like my family's running out the door because we're getting ready to leave for the snowstorm, but I wanted to just tell the witnesses that as well. As far as how everything went in the trial, I really enjoyed it a lot. I thought that the prosecution side started off pretty strong. And then towards the end, I really enjoyed watching Will go at it at the end with the objections and noting the venue. I mean, because as a law enforcement officer, the very first paragraph of your report, you establish venue, and then it has to continue on through trial. And obviously that's one of the elements that need to be met to prove a case. So I thought that was interesting, kind of how that went down and everything, and the objection that was brought up, and just realizing the rules and watching that argument take place. And I think it was it Hannah, I believe, but just very impressed with everybody. I have a 7-year-old daughter, and when I watch you guys do this, I pray that she goes into this path that every one of you have gone in, and just watching you at your age, so professional and so just into what you're doing blows me away. I really enjoyed it very much. And if you guys ever have any questions for me on the law enforcement side, again, my name is Dan Danielson, and I work at the Adams County District Attorney's Office. And you guys can look me up there if you have any questions, but I wanted to let you know I really, really enjoyed it. So thank you.
Real quick, I'm sorry, it was Will who had technical difficulties, and Brendan was the one I was talking about at the end who had the passionate objection. So Brendan, you're still pretty good, but Will, that was really great. I really appreciated your professionalism in that.
I think it was the other way around.
Yeah, I had the technical difficulties. That's Brendan.
Right. Oh, okay. Yeah.
It's
listen
totally
to what I mean, not what I say.
I totally understand.
Yes, I'm sorry.
And it's definitely something to look at, because I actually, when I saw that rule, I felt like it had been violated. But pursuant to the judge's instructions, I didn't take into account, but both sides should probably look at that and make sure, if you advance that no one gets penalized at the next level. But anyway, you are all amazing.
I'll clap.
I have a couple of things. Before I get all sappy and whatnot, let me just say a couple of things. One is that I see this all the time in the real world, so to speak. There is no leading on redirect. any more than there is on direct. So keep an eye on that. It's a legitimate objection. It should be sustained. Well, I don't know if there's any way to do this, but you are lower on the screen than everybody else is. I think you can see that, but I don't know what's to be done about that. But it's kind of, I don't know, it's just off-putting a little bit, I guess. And you're plenty smart and prepared, cool and calm and all, but love to see head and shoulders instead of just head. I'm sure your shoulders are massive and well developed. Hannah, did you, I noticed that at some point you went black and white. Was that intentional?
No, Your Honor.
Okay. Well, I liked it. It took me right back to Bogart and Lauren Bacall, and I thought you might say appropriate like that. But at any rate, I don't know if it's against the rules of the competition, but at least in your personal case, the black and white, I thought was really cool. One thing that I always see also in real life, and even judges do this, they tell juries innocent until proven guilty. It is not until, it's unless. That's a big deal for me because I do defense work, but it is in fact unless. Until suggests inevitability, and it is absolutely not inevitable. So let me tell you this. I'm in my 41st year of practice, which doesn't make me particularly smart, but at least it makes me experienced. And I can tell you, and you've probably heard this, that I have seen lawyers in courtrooms stumble and bumble and not have any clue about what the rules are. And you do. And so I am very impressed about that. I think I ought to give a shout out to our technician as well. Nobody ever loves the technicians. David knows this, but I think it's just pretty outstanding. So really at this point, if you take anything away from my remarks, it is this: you are at state, which is already extraordinary. You have accomplished something that very few people ever in their lives will accomplish. So well done on that. And the only thing I can tell you at this point in the competition is relax. Now, I know ordering somebody to relax is kind of a silly thing. It's like saying, don't think about a pink elephant, but do what you have to do to relax and you'll do better. Not that you did poorly, but the best performances come from relaxed performers. So take a whole bunch of deep breaths, enjoy where you are, because if you're a senior, you won't be here again. And just have fun. You know, I know it's pressure, I know it's stress, yada, yada, but you'll do better if you're having fun. So continue to have fun. See y'all later.
Good job, everybody.
Thank you so much to everyone, and good luck to Team Poland.
Good luck as well to you all.